one read petition for listing your under admission.
What is the subject?
So the petitioner was the Panchayat member and she was removed from her post, your lordship.
The fresh matter.
No, your lordship, pending matter, 23 matter, your lordship. High level, your lordship.
That I am paying for listing on IA for correction of your lordship order, only relating to one date loss.
One day.
Right.
May it please your lordship, with the consent of all the parties, I beg to mention item number 22 of the daily list, your lordship. Your lordship, in this matter, I am led by senior counsel Mr. D. Das. He is out of station, your lordship. It may be adjourned for today, and since the
I appear for one of the respondents, madam.
You are there, you argue. It's a fixed matter.
Your lordship, today's second reading.
You argue. In here, not here, you argue. Start off. Let us hear.
Your lordship, for today, your lordship.
Wait. We'll hear this matter. You start off. Read the file. Tell us what is presence of the city required. What?
Your lordship is out of station.
All right. Hear the matter. Let the matter be called.
I was in the same. I was a respondent in the case.
So get ready.
Yes.
I don't.
May I please, lordship, clear for listing, lordship, matter relating to ceiling land, lordship.
Let it happen.
Lordship, before vacation,
No, no, no.
Monday, lordship,
What is the urgency?
ceiling land, lordship.
Illegal, so let it happen. Please
Before vacation, any date,
no,
lordship.
no, no, not. It's on. It's on 19 July.
My lord, may I prefer mention admission matter, covered matter, as Christian.
Excrete. Excrete the matter.
I am okay. My lord, I prefer listing of this matter, my lord. Here, my lord, the issue was that, my lord, the petitioner had the apprehension that they will be, my lord, evicted from a particular place, my lord, for construction of a municipal market. My lord, we have got the inspection now, my lord, they have dropped the entire project. So this petition needs to be closed. May I pray, my lord, any day next week, my lord, it can be closed. Just for that part. No, only for no, to closure of the petition. They have got the relief. Any day when next week, my lord, only. But, like.
May I please, my lord, I wish to mention for listing on matter, my lord, matter pertaining to the petitioner are the selected beneficiaries of IOI scheme, but their ID was used for another person and house was given to another person.
Fresh matter.
Fresh matter.
Fresh
Not fresh matter, for admission, for admission.
for it. Let it be like
Can it be for vacation?
we may
Sure.
not be able to dispose it. There would be some evidence like.
Sure.
Like 24. 24.
Like,
May I please? There are 5 items in this series. On that day, I had argued 4 items. The last item, Pawan Cement Company, was left out. That I had prayed that I will argue it today.
Why is it different?
No, it's not different. 147. The only thing is that in this case, that proviso is not applicable. Rest all other arguments will be same.
Give it a note. Written argument. Prepare it. Hard to
Right.
Otherwise, it is the 147, 148.
Mine.
Lordship, in item number 1, You file affidavit, Lordship. I want to place few paragraphs of the affidavit for consideration of the Lordship.
Item
7101, 7101, 7101.
7101.
Note.
7.
Lordship, paragraph 4.
Yes.
As a response, in response to the statement made in paragraph 6 of the writ petition, the answering deponent begged to state that in compliance of the notice under section 148 dated 31/3/2017, the SEC company filed a return on 27/4/2017 for the assessment year 2010-11, showing total income at rupees 1,64,62,050 and taxable and payable on at rupees 59,80,122, and consequent to a search and seizure operation conducted in the case, SEC company has filed return under section 153A of the income by acknowledgement number so and so dated 4/9/2014, declaring total income at rupees 1,64,62,050 and payable thereon was shown as rupees 65,76,379, and accordingly assessment under 143(3) read with section 153 was completed on 31/3/2015, determining total income at rupees 2,61,17,000 so and so. Then Lordship, paragraph 5. That in response to paragraph 7 of the writ petition, the deponent begged to submit that in the instant case, notice under section 148 issued to the SEC on 31/3/2017 for assessment year 2010-11, requiring the company to furnish its return income within 30 days. Notice under section 148 was issued with prior approval of principal CIT Quantity 2 through online departmental internet on dated 31/3/2017. Lordship, I have procured the original record that is with me. I'll place before your Lordship at the relevant time. The notice was issued to the SEC based on reason to believe that income chargeable to tax has escaped assessment within the meaning of section 147 of Income Tax Act 1961. Then paragraph 6. That in response to paragraph 8 of the writ petition, the answering deponent begged to submit that the SEC filed return on 27/4/2017, showing total income of rupees 1,64 lakhs and odd, and the tax payable on it was 59,80,000 and odd. In the revised return filed on 4/9/2014, the SEC showed total income of rupees 1,64,62,050 and tax payable thereon was shown as rupees 65,76,379. Hence, the SEC's contention that a return of income was filed on 27/2017 in response to notice under section 148 was identical in all respects with aforesaid revised return filed on 4/9/2014.
First, there was a five-year,
Yes, sir.
then there was a certain
Yes, sir.
pursuant to that
Notice was issued.
is 147.
Yes, sir. Hence, the SEC's contention that the return of income filed on 27/4/2017 in response to notice under section 148 was identical in all respects with aforesaid revised return filed on 4/9/2014. Consequent to search and seizure operation conducted in the case of SEC is incorrect. Further, by filing the return in response to the said notice under section 148, the SEC company has participated in the proceeding. Then also in paragraph 8, that in response to statement made in paragraph 10 of the writ petition, the answering deponent begged to submit that notice under section 142(1) dated 23/5/2017 was issued to the SEC, fixing the case on 14/6/2017. The assessing AR of SEC appeared and submitted copy of return ITR 6, copy of 26 AS statement, audit report in form number 3CA and 3CD, along with annexures and independent audited report, balance sheet and PL profit and loss account, and as such, the SEC has participated in this assessment proceeding. In paragraph 9. In response to paragraph 11 of the writ petition, the exchange has submitted that it is true that the SEC has filed a petition on 7/9/2017 seeking reasons recorded for initiation of proceeding under section 147 before issuance of notice under section 148. And Lordship, paragraph 10 is important. In response to the statement made in paragraph 12 of the writ petition, the petitioner, the answering deponent begged to submit that as requested made by the SEC for the reasons recorded under section 148 of Income Tax Act 61, certified copy of the same was supplied to the SEC company by DICT circular circle 4 Guwahati by letter dated 7/9/2017. The next paragraph, it is submitted, the SEC company submitted a letter dated 9/10/2017 on 12/10/2017 objecting to the
Actually, what was the information that you received leading to reopening of business?
yes, we have explained in our following paragraph. Paragraph 11, Lords. The company submitted a letter on 9/10/2017 on 12/10/2017 objecting to the initiation of proceeding under 147 in its case of assessment year under consideration. The contention of the SEC was that the preconditions prescribed for issuance of notice under section 148 of the Act are not satisfied in the case. It was further contended that the SEC, that the reasons recorded by the assessing officer did not disclose the nature of information and detail thereof. The contention of the SEC are incorrect, inasmuch as the reasons on basis of which the AO formed the belief that there is escapement of the income was clearly mentioned therein, and necessary approval of the competent authority, that is the Commissioner of Income Tax, had been duly obtained online within the prescribed time period. And Lordship, I have opened the record that is available in the record also, and that was supplied to the petitioner also. Then Lordship may come to paragraph 15. In response to statement made in paragraph 22 of the writ petition, the answering deponent begged to submit that the notice was issued on 31/3/2017 with prior online approval of Principal CIT Guwahati 2. While his approval dated 31/3/2017. The reasons for reopening is clearly mentioned in the approval sent to Principal CIT. As such, the contention of the SEC that the notice under section 140 was issued without following mandatory provision of 151 of the Act is not correct. And Lordship, paragraph 16 is important. We have stated.
No, that is what we are asking.
Lordship.
There is no dispute that there was a completed earlier.
Hmm.
Then certain things followed by another 150.
Yes, Lordship. Lordship.
And subsequent to that, what
Lordship, that information we have
information that they have some bogus companies.
Yes, Lordship.
Whether that is sufficient to reopen, I mean, there is a connection.
Lordship, connection is there. Lordship, may please to see the record. Paragraph 16, Lordship, it has been mentioned. Married Lordship, paragraph 16. That in response to a statement made in paragraph 23 of the writ petition, the answering deponent begged to submit that the SEC has alleged that the assessment under section 143, that is section 153A, was completed on 31/3/2015. Consequent to such seizure operation conducted in the case of the SEC, and the facts being available on records does not constitute any tangible materials. The contention of the SEC is not correct. The information based on which the proceeding under section 147 was initiated was received after completion of assessment under section 143(3)/153A. The contention of the SEC has alleged that the information received through Director of Investigation was totally vague, based on suspicion, and that there was no independent inquiry or application of mind of the respondent. Based on information available, if the AO has cause or jurisdiction to know. But suppose that in case any income has escaped assessment, it can be said to have reason to believe that in case that the income has escaped assessment, the said expression cannot be read to mean that AO should have finally ascertained the fact by evidence or conclusion. In determining whether the commencement of reassessment proceeding is valid, there is a prima facie some materials on basis of which the department opened the case. The sufficiency or correctness of the materials is not to be considered. In the instant case, the information was received from Director of Investigation Guwahati, which forms the prescribed authority as per section 133C of the Act, and the reason to be believed was formed on the basis of information so received cannot be said to have been without jurisdiction. Then paragraph 17 explanation is there that in response to paragraph 24 of the writ petition, the SCM did not beg to submit that the information was received from DDIT Investigation Unit 2 based on which the proceeding was initiated under section 147. The contention of the SCC that it was already a part of assessment record in view of the assessment completed under section 143(3), 153A is not correct, as the information was not available on record earlier. Further, beg to submit that the SSC has alleged that the reason recorded was totally vague and does not have any link, live link is not accepted. The contention of the SSC is not correct. The instant case, the information was received after conducting necessary inquiry that the share capital raised by the SSC company requires verification, as most of the LOTs companies are paper companies with no genuine business of their own. In the information so received, it has been observed that most of these LOTs companies belong to well-known entry operator of Calcutta, Sri Narendra Kumar Jain, who has shown under oath that he is an accommodation entry provider who provides bogus accommodation entries, bogus unsecured loan, etc. in lieu of cash commission. A distinctive feature of the paper company is one of which is a trading only shares with no other substantial business oriented transaction, and as such feature in its balance sheet and PLA profit and loss account. It is a matter of fact that the opinion that a paper company is established as so and appearing in our departmental database can only be invoked in Jama Kharchi of public accommodation entry proposal purpose and not for any other work. As such, if Jama Kharchi paper companies appears to an LOT of any company, it can be clearly concluded that the LOTs was for the sole purpose of raising bogus capital and nothing else. As established paper company, hence appearing in the LOTs for any financial year and of any company, thus demands proper scrutiny of the bogus capital raised in the case of the letter. Then paragraph 18, Lordship. In response to paragraph 25, the representative submit that the SCC has already filed return in response to notice under section 148 and participate in the assessment proceeding under section 147. Alternative remedy is available to the SCC by way of appeal against any adverse inference drawn in assessment order to be framed in the proceeding. Then Lordship may skip paragraph 19, Lordship. 20 regarding limitation. That in response to a statement made in paragraph 27 of the writ petition, the answering deponent submit that in the instant case, the income chargeable to tax which has kept assessment exceeding 1 lakh rupees and assessment year falls within limit of 6 years. Therefore, notice under section 148 was validly issued after taking prior approval of the jurisdictional commissioner of the income tax. Then paragraph 22, Lordship. In response to statement made in paragraph 29 of the writ petition, the answering deponent begged to submit that the contention of the SCC is not acceptable. The reasons recorded is clearly stated that the SCC's income 1 crore 58 lakhs and all chargeable to tax has escaped assessment within the meaning of section 147 of the Income Tax Act. The petitioner has alleged that the materials facts have not been examined and there was no application of mine not accepted. The answering deponents humbly beg to submit that an independent inquiry is not required for formation of reason to believe. Inquiry is to follow during course of assessment process. Then one contention was that the the information provided is not a valid authority. Paragraph 23, in response to statement made in paragraph 30 of the writ petition, the assailing deponent submit that the contention of SC is not acceptable as the reason to believe was formed on the objective satisfaction of AO based on specific information received from DDIT investigation unit 2 working under DIT investigation Guwahati, which forms prescribed authority under section 133C of the Act. Then let's see paragraph 25. That in response to the statement made in paragraph 32 of the writ petition, the examining deponent begged to submit that the contention of the SEC is not acceptable. The SEC has filed return in response to notice under section 148. The SEC has also complied through his AR to notice issued under section 143(2) and section 142(1) dated 23/5/2017 by appearing before the AO on 14/6/2017 and 7/9/2017 fixed date of hearing and submitted various documents, namely copy of acknowledgement of return, computation of income, copy of IPR 6 filed for the year assessment year 2010-11, Form 26AS audit report in form of 3 CAD and copy of audited balance sheet and profit and loss account and details of share premiums received in chart. As such, the SEC has participated in the proceeding initiated under section 147 and midway decided to file this writ petition, which is clearly an afterthought straight way to avoid the assessment proceeding. Then paragraph 26. The deponent begged to submit that the SEC filed the return in response to notice under section 148 on 24/7/2017 by e-filing acknowledgement number so and so. Thus, the SEC has participated in the proceeding initiated under section 147. The proceeding cannot be declared void as there is no legal infirmity in the proceeding. Then let's see paragraph 27 is so important. The deponent begged to submit that the SEC filed letter dated 9/7/2017 and 7/9/2017 requested to communicate the reasons recorded for issuing notice under section 148. The same was communicated to the SEC by this office letter dated 7/9/2017. The SEC filed objection by letter dated 9/10/2017 received on 12/10/2017. The objection raised was disposed of by the passing and speaking order 24/10/2017. Proceed then with regard to alternative remedy. In response to a statement in paragraph 35 of the writ petition, submit that the contention is not correct as the petitioner has records of appeal, revision, petition to the High Court and Supreme Court if the adverse inference is drawn against the SEC in the assessment year. Proceed, only notice was issued, they responded. And in the meantime, they approached the Supreme Court and the entire proceeding was stayed. Nothing has been proceeded. And there is a reasonable reason to believe to proceed under section 147. And furthermore, they participate in the proceeding as stated in foregoing paragraph.
No,
And-
but yes, you do have a power under 147
Not
reopen. But subject satisfaction.
yes,
You say that the information
TSC investigation.
who is the prescribed authority,
Yes, sir.
they have disputed by referring to the litigant. Say that not a prescribed
Prescribed authority.
authority. CIT Delhi. CIT Delhi or CIT. This is what idea. The other is that how many assessments were there earlier? One or two
One, my lord,
One.
regular assessment, 143, that with 153
153C, that is after search.
after. Prior to search, there was no assessment.
Prior to search, there was no.
That one, 153A
What's paragraph 4? Probably paragraph 4, last 3 lines. The tax payable thereon was shown as rupees so and so, and accordingly assessment under section 143, read with section 153, was completed on 31/3/2015, determining total income of rupees 2 crore 61 lakh. And record is with me, Lordship. Lordship may peruse the record. If it is the statement is incorrect.
You will pay, you have already determined this amount.
Yes, Lord.
You have imposed whatever taxes you required.
Mhm.
Subsequently, you have paid some income.
Yes, Lord.
Now, there are government paid capital. The effect that company belonging
One
to the
Jane.
NJ or what,
Lord.
the established company,
Yes, is a,
established paper company,
yes,
you have found some entry, their books of account,
yes, Lord.
where is that?
That is there. And the reason to believe was communicated to them.
To believe does not. Secondly, these funds have been available when the assessment earlier was made.
Lordship, please to see the speaking order whereby their objection was rejected.
We have seen the finding
Yes, Lordship. It is mentioned
and
there.
you have mentioned that these funds are there. That and there.
Yes, Lord. And on the basis of that information, notice under section 147 was issued. And
Any information that here, enough,
no, that was no, Lordship. That information was inquired into initially, and approval was obtained, and thereafter notice was issued.
how to let us say that unless the out of and there relating
And his statement was recorded. He admitted all this. James' statement. It is also available on the record, Lord. No, that is there. Lordship may please to see the objection. Page 181. Finding and reasoning and conclusion. Merit. The summation heading is finding and reasoning and conclusion. The submission of SEC is considered thoroughly. The purpose and object of law behind initiation of proceeding under section 147 is to protect the interest of the revenue by bringing to tax the escaped income, and reason to believe requires relevant materials to assume that the income has escaped assessment. The reason recorded for reopening are absolutely and undoubtedly based on rational, relevant and materials facts related to case of the SEC, and thus reopening under section 147 is as per law and justice. And some judgment has been quoted. Last paragraph, the section 147 authorized and permits the assessing officer to assess and reassess income chargeable to tax if has reason to believe that the income of any assessment year has escaped assessment. The word reason in the phrase reason to believe will mean cause or justification. If the assessing officer has cause or justification to know or suppose that the income has escaped assessment, it can said to have reason to believe that the income has escaped assessment. The said expression cannot be read to mean that the assessing officer should have finally ascertained the fact by legal evidence or conclusion. The function of assessing officer is to administer the statute with solicitude for the public exchequer with an inbuilt idea of fairness to taxpayers.
But you have to relevant material.
Lordship,
You will have to see private is satisfy the material with information was
Lordship.
an information which was not disclosed willfully
Yes,
by
sir.
them and not available in the books of account and when made the SS
Lordship, that why the notice was issued. They participate, initially they participated. They submitted some documents. And in the meantime, they approached the Honorable Court without allowing the assessing officer to come to conclusion.
there are two parts. One is
Yes,
the other is proceed to make the TS, take inquiry exam. How has it been determined? Proceed to TS. But go to embark on you don't satisfy. These were the reasons which were deliberately not before the assessing authority asked or which cannot be discernible from the without this.
Lordship, my humble submission in this case, this is a writ petition, Lordship. It is not an appeal. And no evidence has been laid by the SEC before the assessing officer. At the stage of issuing notice, Lordship, like the courts of repeat,
Were aware that 147 is not a routine.
not definitely not routine.
That
Lordship,
you,
first,
you were suspect that there is some reason. Issue a notice that make an inquiry.
Yeah.
Like that.
no, Lordship, here, first we have to take approval under 147, Lordship. I think 47.
It is where
That Lordship may peruse from the record itself, because reason that approval was supplied to the petitioner, and they file objection. That was also speaking order was passed.
181 is the rejected.
Yes, Lord. Their objection, Lord. But may please to see.
If materials of which were convicted and satisfied, but
That is stated, Lordship.
you have referred to the case.
Lordship, page 183. Page 183, last second paragraph. In the instant case. In the instant case, information has been received from the Directorate of Investigation that the company Messrs Mukunda Infotech Private Limited has raised capital with allotment of on 31/3/2010 to the tune of rupees 1 crore 58 lakhs with the face value of rupees 100 and premium 900. Most of the allottees companies of that particular corresponding year read with to the capital of Messrs Mukunda Infra are paper companies
That's what
which exist only on paper with no
that's what
genuine.
we want to know. How have you arrived at the conclusion that the paper company?
No, that
There
is
has to be some investigation.
yes,
That-
investigation by Lordship by conducted by the investigation director of investigation.
Where is that information?
Yes, that is there, Lordship. I'll place before.
Yes.
Their materials are available on the record lot. And their objection.
Yes.
Their objection was duly addressed to. This was disposed of and materials were disclosed. And each and every information is not required to be through the petition. Lordship can peruse. And actually furthermore, only the note,
All right.
Lordship, that he is a pescar authority. Lordship, he has obtained the approval from the concerned authority. And Lordship, regions recorded, that is also that was supplied to the petitioner. It says that as per information, it is found that Mukund System and Networking Private Limited, PAN number so and so, has raised capital to the tune of rupees 1 crore 58 lakhs by allotment of shares with allotment face value 10 and premium of rupees 19. As per information received, most of the allotee companies are paper companies which exist only on paper with no genuine business in their own. As per data prepared by DIC Investigation Kolkata, most of these companies are belong to Sri Narendra Kumar Jain. Sri Narendra Kumar Jain, during the course of survey conducted on 11/4/2014, has shown under oath that he is a accommodation entry provider who provides bogus accommodation entries, bogus unsecured loan, etc. So I have reason to believe that the SEC's income of rupees 1 crore 58 lakh chargeable to tax for the financial year 2019 with relevant year assessment year 10-11 has escaped assessment within the meaning of section 147 IT Act, and it is fit case for issuance of notice under 148. The reason to believe when the information was disclosed to the petitioner, and now Lordship, notice has been issued. Initially they participated, they provided some information. In the meet, they approach this honorable court. So alternative remedy is available. If Lordship suppose the assessment goes against them, there is a remedy is available with them to approach the authorities, even the they can file appeal, and ultimately to this honorable court and to the Supreme Court also. And regarding authority, Lordship, we have clearly stated in our affidavit that he is a authorized officer under section 133 capital C. I'm relying on my judgment passed by the ordinary bench of this honorable court, that all the judgments of honorable Supreme Court as well as different high courts has been taken into consideration. My landlord senior was also the counsel of petitioner. Paragraph 41 onward at page 14. Page 14, paragraph 14 onward. Paragraph 41. From the pleading and respective contentions, various issues have arisen in the writ petition relating to non-fulfillment of condition precedent or initiation of reassessment proceeding, as well as the violation of provision of section 151 of the Act of 1961. Further, that in two writ petitions, the initiation of reassessment proceeding have been challenged on the ground that the entire region have not been furnished, for which the reassessment proceedings should be nullified. Taking into account the said issues involved, this court broadly enumerates the following points of law to be determined. A, whether the assessment required for initiation of reassessment proceeding under section 147 of the Act of 1961, and to what extent the court under Article 226 can interfere. Whether the provision of section 151 of the Act of 61 are mandatory in nature and non-compliance with the mandate would nullify the reassessment proceeding. C. Whether non-communication of region would render the reassessment proceeding vague, and what extent interfere can be made by this court under Article 226 of the Constitution. From the purpose of deciding issue number A, this court finds relevant to take note of section 147 of the Act of 1961, which authorizes and permits the assessing officer to assess or reassess the income chargeable to tax if he has reason to believe that the income for any assessment year has escaped assessment. This phrase reason to believe has been subject matter of debate before the Supreme Court and various High Court. In case of Naranappa Supra, the Supreme Court, in the context of proceeding under section 34 of the Income Tax Act 1922, explained that the phrase reason to believe would mean that if there are in fact some reasonable grounds for income tax officer to believe that there has been non-disclosure as regards any fact which could have a materials bearing on the question under assessment, and the existence of such reasonable grounds would be sufficient to give jurisdiction to the income tax
These
officer.
are the repeat.
Not see?
Has been repeated.
No, this is a writ petition.
Huh?
It was under writ petition.
Right?
Not
Any appeal filed?
No, my lord, this was a against the writ petition. Here the facts were totally different, my lord. Here that proviso was not applicable in all these cases. And apart from that, there are certain other issues also which I will place once my learned friend.
It was further opined that whether the ground would be adequate or not in the matter of court to investigate, or in other words, the sufficiency of ground which induce the income tax officer to act not a justiciable issue. However, it was also opined that it was open to the SEC to contend that the income tax officer did not hold the belief that there has been such non-disclosure, or in other words, the existence of belief can be challenged by SEC, but not the sufficiency of reason for the belief. It was categorically opined that the expression reason to believe appears in section 34 of the Income Tax Act 1922 did not mean a purely subjective satisfaction on the part of the income tax officer. The belief must be in good faith and cannot be merely pretense. Paragraph 2 of the said judgment is quoted herein below. On behalf of the appellant, Mr. Gopal Krishnan contended in the first place that the reason which induced the income tax officer to initiate proceeding under section 34 were justiciable. It was submitted that the reason should have been communicated by the income tax officer to the SEC before the assessment was made. In this connection, the further argument of the appellant was that those reasons must be sufficient for a prudent man to come to a conclusion that the income has escaped assessment. In our opinion, there is no substance in any one of these arguments. It is true that two conditions must be satisfied in order to confer jurisdiction on the income tax officer to issue the notice under section 34 in respect of assessment beyond the period of 4 years, but within a period of 8 years from the end of the relevant year. The first contention is that the income tax officer must have reason to believe that the income, profits and gain chargeable to the income tax had been under assessed. The second condition is that he must have reason to believe that such under assessment has occurred by reason of either one, omission or failure on the part of the SEC to make a return of his income under section 22, or omission to failure on the part of the SEC to disclose fully and truly all the materials facts necessary for his assessment for that year. Both these conditions are conditions precedent to be satisfied before the income tax officer requires jurisdiction to issue the notice under the section. But the legal position is that if there are in fact some reasonable grounds for income tax officer to believe that there have been any non-disclosure as regards any fact which could have a material bearing on the question of under assessment, that would be sufficient to give jurisdiction to the income tax officer to issue notice under section 34. Whether these grounds are adequate or not is not matter for the court to investigate. In other words, the sufficiency of the ground which induced the income tax officer to act is not a justiciable issue. It is of course open to the SEC to contend that the income tax officer did not hold the belief that there had been such non-disclosure. In other words, the existence of the belief can be challenged by the SEC, but not the sufficiency of the reason for the belief. Again, the expression reason to believe in section 34 of the Income Tax Act does not mean a purely subjective satisfaction on the part of the income tax officer. The belief must be held in good faith. It cannot be merely a pretense. To put it differently, it is open to the court to examine the questions whether the reason for the belief have a rational connection or a relevant bearing to the formation of the belief and are not extraneous or irrelevant for the purpose of section. To this limited extent, the action of the income tax officer in starting proceedings under section 34 of the Act is open to challenge in a court of law. Then paragraph 43. In the backdrop of the above proposition to settle by the Supreme Court, insofar as section 34 of Income Tax Act 1922, this court now finds relevant to take note another judgment of the Supreme Court in case of Assistant Commissioner of Income Tax versus Rajesh Jhaveri stockbrokers, reported in 2008-14 SCC page 208, wherein the Supreme Court considered the import of the phrase reason to believe as provided in section 247A of the Act of 1961. While interpreting the said phrase, the Supreme Court considered both section 147 and 247A of the Act of 1961 and observed that section 147 authorizes and permits the assessing officer to assess or reassess income chargeable to tax if he had reason to believe that the income for any assessment year had escaped assessment. The word reason to reason in phrase reason to believe was opined by the Supreme Court to mean cause or justification. It was further opined that if the assessing officer had cause or jurisdiction to know or suppose that the income has escaped assessment, it can be said to have reason to believe that the income has escaped assessment. It was also observed that the expression reason to believe cannot be read to mean that the assessing officer should have finally asserted that the fact by legal evidence or conclusion, inasmuch as the function of the assessing officer is to administer a statute which solicitude for the public exchequer with an inbuilt idea of fairness of taxpayers. Paragraph 44. Before further proceeding, this court finds it relevant to take note of the very pertinent amendment to section 1 Act of 61. So far as provision of section 147 by Finance Act 1989. Section 147 prior to 1489 stipulates 12 conditions for reopening of assessment, that is, the assessing officer has to reason to believe, and the reasons were to be recorded for the purpose of initiation of the reassessment proceeding. However, with effect from 1489, only one conditions remain out of the two, that is, assessing officer has had to have reason to believe that the income has escaped assessment. At this stage, this court finds relevant to take note of the judgment of the Supreme Court in the case of Commissioner of Income Tax versus Calvinator of India Limited, reported in Sonso, and more particularly in paragraph 5, 6, and 7. In the said judgment, the Supreme Court noted that the fulfillment of two conditions which were there to confer jurisdiction upon the assessing officer to make a back assessment was done away with the amendment made to section 147 with effect from 1489, and only conditions which remained was where the assessing officer has reason to believe that the income has escaped assessment. It was observed by the Supreme Court that post 1489, the power of reopening assessment is much wider, for which one needs to give systematic interpretation to the word reason to believe, so that the power under section 147 of the assessing officer is not arbitrary and unabridged to reopen assessment. It was observed in paragraph 7 that post 1489, the assessing officer would have the power to reopen provided that there are tangible materials to come to a conclusion that there is escape of income of assessment. Paragraph 5, 6, 7 of the sales judgment are quoted here below. Paragraph 5. On going through the changes quoted above made to section 147 of the Act, you find that the prior to Direct Tax Law Amendment Act 1987, reopening could have been done under the above two conditions and fulfill the above two conditions alone conferred jurisdiction on the assessing officer to make assessment. But in section 147 of the Act, with effect from 1489, they are given go by, and only one condition was remained, namely, where the assessing officer has reason to believe that the income has escaped assessment, conferred jurisdiction to reopen the assessment. Therefore, post 1489, power to reopen such much wider. However, one needs to give systematic interpretation to words reason to believe, telling which we are afraid Section 147 would give arbitrary powers to the assessing officer to reopen assessment on the basis of mere change of opinion, which cannot be per se reason to reopen. 6. We must also keep in mind the conceptual difference between power to review and power to reassess. The assessing officer has no power to review, he has power to reassess. But reassessment has to be based on fulfillment of certain preconditions. And if the concept of change of opinion is removed and contented on behalf of the department, then the garb of reopening of the assessment review would take place. One must treat the concept of change of opinion as inbuilt test to check abuse of the power by assessing officer. Hence, after 1489, the assessing officer has power to reopen provided there is a tangible material. To come to conclusion that there is a escapement of income from assessment, region must have a live link with the formation of the belief. Our views get support from the change and made to section 147 of the Act as quoted here in above. Under the Direct Tax Law Amendment Act 1987, Parliament not only deleted the word reason to believe, but also inserted the word opinion in 147 of the Act. However, on receipt of the representations from the companies against omission of the word reason to believe, the Parliament reintroduced the said expression and deleted the word opinion on the ground that it would vest arbitrary power in the assessing officer. Paragraph 45. The above observation that the power to reopen is subject to there being tangible materials to come to the conclusion that there are escapement of income of assessment have been reaffirmed by Supreme Court in its recent judgment rendered in the case of Deputy Inspector of Income Tax versus M.R. Saha Logistics, reported in 22/2/14 SCC 101. Paragraph 46. This court also finds it is pertinent to take note the observation of the Supreme Court in the case of Hulchand Bajranglal and others, reported in Centro, which throws light on the aspect of subsequent information received taking into account the reopening of the assessment. It was observed by the Supreme Court that the income tax officer requires jurisdiction to reopen assessment under section 147A as it then exists, read with section 148 of the Act of 1961. Only if on the basis of specific, reliable and relevant information coming to his possession subsequently, for which he has reasons which he must record to believe that by reasons of omission or failure on the part of the SEC to make a true and full disclosure of all material facts necessary for his assessment during the concluded assessment proceeding as a part of his income, profit and gain, chargeable or income tax as escaped assessment. It was further opined that the assessing officer may start reassessing proceedings either because some fresh facts come to the light which were not previously disclosed, or some information with regard to the facts previously disclosed came into his possession, which tends to expose the untruthfulness of those facts. In such circumstances, it is not a case of mere change of opinion or drawing a different inference from the facts were earlier available, but acting on fresh information. Since the belief is that of the income tax officer was opinion that the sufficiency of the reason for forming his belief is not for the court or judge, but it is open to an SSC to establish that there, in fact, exists no belief or that the belief was not at all bona fide one and was based on vague, irrelevant, and non-specific information. To that limit extent, it was opined that the court may look into the conclusion arrived at by the income tax officer and examine whether there was a materials available on record from which the requisite belief could be formed by the income tax officer, and further whether that materials had any rational connection or a live link to the formation of requisite belief. Paragraph 47. This court further find it relevant to take note that the judgment of the Supreme Court in the case of State of Uttar Pradesh versus Aryabhat Chawla Udyog Limited reported in so, where the Supreme Court has opined that materials on the basis of which the assessing authority based its opinion must not be arbitrary, irrational, vague, distant, or irrelevant. It must bring home the appropriate rationale of the action taken by the assessing authority in pursuance of such belief. In case of absence of such materials, the action taken by the assessing authority on such reason to believe would be arbitrary and bad in law. Further to that, it was also opined that in case of the same material being present before the assessing authority during both the assessment proceeding and the issuance of notice for reassessment proceeding, it cannot be said by assessing authority that reason to believe for initiation of assessment is an error discovered in the earlier view taken by it during original assessment proceeding. Further to that, the Supreme Court also observed that in the said judgment that the standard of regions exercised by the assessing authority is that of honest and prudent persons who would act on reasonable ground and come to a consent conclusion. Therefore, the necessary security is that the mere change of opinion while
Yes,
pursuing
Mr. KL,
Lordship. So, Lordship, if
Now,
we
one thing is that the requirement is very important under the proviso
Lordship,
and the requirement. Right.
57.
Mr. Goenka, according to you, this notice is issued under proviso
Proviso,
148.
proviso to section 147. Because my assessment was completed under section 143(3) of that. After 4 years, if they want to reopen my case, they have to overcome the proviso, conditions of the proviso.
Which proviso exactly?
First proviso, my lord,
First,
I'll just read. Provided that where an assessment under subsection 3 of section 143 or this section has been made for the relevant assessment year, no action shall be taken under this section after expiry of the 4 years from the end of the relevant assessment year, unless any income chargeable to tax has escaped assessment for such assessment year by reason of failure on the part of the assessee to make a return under section 139 or in response to notice issued under subsection 1 of section 142 or section 148, or to disclose fully and truly all material facts necessary for his assessment for that assessment year.
Now, is it by of an assessment
My lord?
proceeding under 147?
Yes, my lord.
We are not, the stage has not reached to decide on the orders of proceeding, 147. Stage is at the notice. It's at the notice. stage.
Notice stage, ma'am.
So whether at the notice stage, this condition is required to be satisfied.
Yes, my lord. Unless these conditions are required, these are satisfied, they cannot issue me notice under section 148. This is the very foundation.
No, in order to find out that there was a reason, by reason of failure, there was an escapement of income.
Yes, my, yes.
It will require an inquiry into your books of
It
account.
will, my lord, they have to make a clear statement in the regions recorded that so and so, so and so, so and so, income was not disclosed by me, so and so material was not disclosed by me, and therefore they have reason to believe me.
No.
I have,
How will they make that? How will they make that? How will they give those reasons without examining your books of account?
my lord, that is what has been held by Honorable Apex Court and various other courts. My lord, if your lordship permit me, I would once again take your lordship to the series of judgments which say that there has to be a clear statement in the regions recorded.
Yeah.
The propositions which I made on that day, my lord.
Which judgment of the apex court?
Yes, my lord, I'll just.
Mr. KL will just come back. Just-
My lord, the proposition made by me was that if the assessment proceedings are to be initiated after a period of 4 years on the ground that the assessee failed to disclose fully and truly all material facts, then the assessing officer must state so in the regions recorded, and the action should be founded on such regions. My lord, the case laws which I referred. Now, first case I referred was serial number 8 of my compilation.
Cedric,
Cedric D'Souza. Compilation page 51, 52.
yes.
Para 8, 11 and 12, my lord. Para 8, my lord. One aspect of reopening of the assessment through various judicial pronouncements, certain basic parameters stand firmly established. Section 147 of the Act empowers the AO, if he has reason to believe that any income chargeable to tax has escaped assessment, to reassess the income. Under Section 147, however, contains a proviso that no action under Section 147 will be taken after a period of expiry of 4 years from the end of the relevant assessment year, unless the assessee has failed to disclose fully and truly all material facts necessary for his assessment for that assessment year. The conditions specified in Section 147 are jurisdictional requirement. And unless they are fulfilled, no proceeding under these sections can be taken. It is open for the assessee to challenge the initiation of reassessment proceedings if the assessee is able to show that jurisdictional requirements are not met. The assessing officer must disclose reasons why reassessment proceedings are being taken out. Further, the assessing officer is not permitted to improve upon the reasons furnished to the assessee. Thus, validity of the initiation of the assessment proceedings will be determined only by reasons furnished by the assessing officer to the assessee. If the assessment proceedings are to be initiated after a period of 4 years on the ground that the assessee failed to make full and true disclosure of all necessary facts, then the assessing officer must state so in the regions, and the action must be founded on such regions. My lord, in the regions recorded, your lordship will kindly see it.
So that's okay. Then any other Supreme Court judgment?
Then, my lord, there are in our own High Court, my lord, in Sonitpur Solvex, compilation serial number 12. Page 87, 9. Is at page 80,
Seven.
7 to 91, my lord. At para 12, 13 and 16 to 34. My lord will see kindly para 28, first page 90. In the case in hand, the transport subsidy which has been received by the assessee was duly disclosed by the assessee in the audited accounts and the statement submitted by the assessee along with the assessee's return of income for the assessment year so and so. In fact, the paper book filed before the tribunal contains copies of such assessee's audited balance sheet and statement submitted along with the return. The balance sheet admittedly contains the details of receipt of transport subsidy. Now, in my case, in these cases, we had disclosed the receipt of share capital even prior to the date of search when the original return was filed. So this is not something which has come subsequently to their notice. And my lord, I place reliance on Corporation Bank's case.
No, their ground is,
My lord,
it's not that you did not disclose
Yes.
allotment of shares.
Yes.
But these allotment of shares were only to paper company
my lord.
for the purpose of their bogus company.
Huh. Now, my lord, I'll just I'll meet that, my lord. Kindly come to para 32, my lord, at page 91. Para 32. In fact, there is not even a particle of acquisition in the reassessment order to show that the escapement of income in the present case was because of the omission or failure on the part of the assessee to make a return under section 139 or in response to a notice issued under subsection 1 of section 142 or 148
So that is what I am trying.
or to disclose fully and truly.
No, that's what we are trying to understand. One thing is non-disclosure.
Non-disclosure.
The other thing is disclosure. But where perusal will not reveal the nature of transaction which were taken
Yes,
unless you make further inquiries, find out.
my lord. My lord, I had submitted in the last occasion, my lord. My case, a case cannot be reopened for the purpose of making roving inquiries to fish out some material.
Correct.
Now,
But this is the A,
yes, my lord.
this is an information from Director of Investigation.
Maybe, my lord, maybe now any information that is received from the director of investigation per se cannot be a part of information unless they make some more inquiries and come to a conclusion, yes, that and that is to be reflected in the regions those have been recorded.
Make these inquiries, they'll have to initiate the process. How
They-
will they make the inquiry?
My lord, they should have made inquiries before issuing notice under section 148.
How? From which basis? Unless the books are compared and examined,
My lord,
how will the,
they,
what will be the, what will be the?
My lord,
the
my lord, they have plenty of powers available with them. Section 131 is one of them. Section 133 is there. Section 133A is there. Section 133(6) is there. They have
Calling for the book.
calling for the books, calling for the information, making inquiries, sending to the inspector at their place. There are many ways of making inquiries. They have not done anything, my lord. And kindly see the regions those have been recorded at page 172 again, once again.
170 for the writ petition.
Read petition, my lord, annexure 15.
Yes.
My lord, just a minute. My lord, I'll just read the regions recorded. Yes. As per information, it is found that Mukund Systems and Networking Private Limited raised its capital to the tune of 1,58 lakhs by allotment of shares with a allotment face value of 10 and premium of ₹90. As per the information received, most of the LOT companies are paper companies which exist only on paper with no genuine business of their own. As per the data prepared by DIT investigation, first they say as per information, they have not disclosed what information. Then they say data prepared by DIT investigation. Most of these companies belong to Narendra Singh Jain, Narendra Kumar Jain. See, Narendra Kumar Jain, during the course of survey conducted on ITNA, had sworn under oath that he is an accommodation entry provider who provides bogus accommodation entries, bogus unsecured loan, etc. Who is Narendra Kumar Jain, my lord, we don't know. What statement he has given, we don't know. Whether he has taken our name or we don't know, my lord. This case pertains to assessment year 10-11, that is financial year 9-10. And a survey was conducted in his premises on 11/4/2014. So, my lord, we don't know what is the information available with them. So then she says, so I have reason to believe that the assessee's income of 1,58 lakhs chargeable to tax for the assessed financial year ITNA, with the relevant assessment, ITNA has escaped assessment within the meaning of section 147. So it is a fit case for issue of notice under section 148. Since the case is beyond 4 years, the approval of so and so is taken through proper channel.
No, that is okay.
My lord,
Yes.
my submission is, as I submitted the last occasion, whenever there is a challenge to a notice under section 148. My lord, the regions are required to be read as those are recorded. Nothing, no addition, no subtraction, no modification, nothing is permissible. And there is a series of judgments on that point. And my lord, I have also mentioned, they cannot supplement the regions by producing the records before your lordship. They cannot keep something under their sleeves when they recorded the regions, and then one by one they will try to produce before the Honorable Court. My lord, I have also submitted that in Lakhmani Mewal Das case, the Honorable Apex Court has clearly said that even the court cannot also replace its own opinion of that of the assessing officer. My lord, my submission is there is nothing in the regions recorded. By way of affidavit, they have tried to introduce something new, which was not there. And now also they are trying to introduce something new. So the entire proceedings has to remain confined only to the regions recorded, my lord. This is my humble submission.
Yes.
In the regions recorded, my lord, they have not said that I have failed to disclose this particular thing fully and truly. Nothing is there. My income tax return was filed prior to the date of search, much prior to the date of search, where this capital of 1 crore 50 lakhs, 58 lakhs is duly disclosed. And this is and thereafter my 143.3 assessment has taken place. They have not found anything incriminating in course of the assessment. No incriminating material.
Because that information was not there, the relevant point.
Which information, my lord?
Now, on the basis of which they are trying to reopen, that
Huh.
information was not there with them earlier.
Huh.
So, in view of this information available, they are now seeking to reopen.
No, but where is the information in the regions recorded? In the regions recorded, there is nothing, my lord.
So, it's with the entire reasons are not to be furnished. The gist of the reason, gist of the materials available, furnished to you.
My lord, my submission is when the case falls within the second, under the proviso, my assessment has already been completed under section 143.3. They have examined everything. No incriminating material has been found. My case has been approved by their higher authorities. So Lordship will kindly see the assessment order. At page 140, page 146, 147, my lord. I am referring to the particular paragraph.
Page number?
Page 146.
Yes. This is part of
Assessment order, my lord. Last part of the assessment order. During the course of assessment proceedings, the seized material was verified and examined. The assessee was asked to explain with supporting documentary evidence wherever required by various requisitions, questionnaires attached with the notice under section 142(1) regarding the entries of transactions in seized material and assets found. On confrontation, the SSC has submitted his reply on various dates as well as the AR explained the facts during the hearings. The SSC was asked various questions as under based on the various seized material as mentioned above. The SSC's case has been examined with reference to replies filed and submissions and documents furnished in response to questionnaire issued and queries raised during the course of hearing. After verifying the income shown and information furnished, the SSC's total income is computed as under. Then, my lord, next page.
Yeah.
Next page, my lord. This order is passed with the prior approval of the Additional Commissioner of Income Tax Range 4, Guwahati, issued under Section 153D of the Act, YD letter number so and so so. Not only they have examined everything during the course of the assessment proceeding, and nothing incriminating relating to share capital was found. The order has been approved by his higher authority also. He has also not found anything, my lord. Then, my lord, in the regions recorded, where is the live link between the materials found, the regions recorded, and escapement of income? There is nothing, my lord.
Okay.
And
That's all. I heard you in detail.
my lord,
Mr. Kyal
No,
is the primary thrust of the argument are that number one, not satisfied point.
yes, reasons were,
Number two, reasons which you have given and the does not disprove that there is failure of part truthfully more particularly where an assessment has already been done. Under the circumstance, why one would number three, information came from an authority not prescribed. Assuming it is prescribed, the same authority has to apply merely because some authority has some reason. No ground to reopen it.
no, it has seen the regions recorded. I am again placing logic. This is very clear. As per information, it is found that Messrs. Mukund system,
No, see, not sufficient to say as per information. That something in that information to connect the petitioner that the other person that there was a deliberate and willful attempt to escape.
no, if the reasons recorded, it is clear on the, I am placing again logic. The raise is
And coupled with the fact of the submission that there are other provisions under the Act, to have taken records to make necessary
Not if the inquiry is initiated and notice was issued, and they initially they
but
participate.
that inquiry cannot be find out whether the
No, because on the basis of specific information, notice was issued. And initially they responded.
you have to tell us who are the submissions made. That on the basis of the information received, does it entitle you to go for a further inquiry by examining the proof after you receive and after you issue the information? Or you have to satisfy your Yes, on the basis of the information, we have made inquiries as per the other provisions available. We have found that there is a statement and the statement is a deliberate, willful attempt. Therefore, it
My submission, whether it is at all necessary. The prima facie opinion is to be arrived at the initial stage. And after,
is relied on judgment.
no, Lordship, there I have also relied on judgment that is very clear. There are three Supreme Court judgment recorded in the judgment that plays before Lordship. Yes, it should not be arbitrary. And some restriction is there. Whether that has been followed by the authority or not, that is, the Lordship can look into it.
Has to be decided on a case to case basis of the fact. How do you decide whether it is arbitrary or not?
No, no, definitely, Lordship. That's why Lordship has placed the record.
Your information, as it stands today, your information is with that some other person. That some other person has purchased,
No, no,
has
Lordship.
been allotted certain shares.
He has the share capital purchased by him from that person only. That has been reflected in their earlier assessment.
Let us
Return.
hypothetically let us give an example.
Lordship,
That there is a particular person named certain shares. Now anybody can buy shares by applying
yes, sir.
your shares are available. ready.
That can,
Subsequently, find out that the person who was allotted share.
is a broker.
Should there be no live connection between the company who was allotted share to come to a finding that this is a case where both parties are in escapement of. How will you find out from the accounting survey? You already examined this account.
No, earlier it was account and the assessment was completed. After 4 years,
Therefore, MFSC, it appears that you are proceeding for reassessment.
yes,
Proceed for reassessment. You have the sufficient.
yes, Lordship. That we have to place and the Lordship has to satisfy whether these materials are there or not. I place the record, Lordship, may examine whether it is there sufficiency of,
You have to point out.
I'll point out, Lordship. I'll examine the record and I'll place before all.
You examine in detail and
No,
tell us that
yes.
these are the materials which are available.
Lord, that
Number two, assuming these materials are not material found out by the SSC or by some other authority,
some authority that has been informed to
whether
us.
only on the basis of that information can you proceed further.
Yes.
Or it is mandatorily required for you. Prima facie does appear that you have to proceed for making an inquiry. Find out how the truth,
We have interlinked with.
and then you proceed. There is no difficulty that there are reasons. They think the reason, given the reason applied, should have an opportunity. But the facts of this case, does it require completed book examining?
Yes, that is there. I'll attest to Lordship and I'll allow me some time.
Very well. Mr. Goenka, we have heard you. Let him come back with the records or explanation in the records. Subject to that, we'll give you a liberty of reply.
My lord, my only submission is at this stage, they cannot supplement or improve upon the reasons now
That we'll examine.
by producing records or by producing any other. This is a settled law.
That will examine.
This.
But this is not the case that we have manipulated the record.
No, he's not suggesting that. He's saying that the reasons which you furnished
No, definitely.
were not very elaborate. Whether you can further supplement.
That I'll attest to.
My lord, the last hearing, Lordship had directed me to file a synopsis.
You can file it.
We can file only on the legal proposition or even on the facts,
No, just give a gist of the fact
gist of the fact.
with regard to each of these cases.
My lord.
Most of them are similar, but 3 lines of fact which are undisputed. And then the legal proposition. and the judgments which you are relying on in support of this proposal.
And about the last case, Pavan Cement case, I'll give a note.
Should be a very precise synopsis,
Precise.
that's all. Nothing more. I heard that. On 23rd July.
Lots,
23rd July.
lots.
I will not get it. Second July,
Much of.
matter be treated as part of it.
Good. Item number 10, this and maybe taken one. My learned child will start, my lord. Because
You refresh our memory.
Okay. The petitioners hereof are, my lord, appointed as work charge employees, my lord, in the PH department, my lord. And in the year 81, 83, and during that period, my lord. And those all these petitioners, they have been given their regular scale of pay, increment, and EB crossing, revised pay, all benefits like other regular government employees, they have given till the date of retirement. Some of the petitioners have been given the provisional pension, they are also getting now. Now, my lord, what happened? These petitioners, after the retirement, their proposal for pension, the file for pension has been moved, and it is the AG has returned it back, asking the question whether their services have been regularized by the authority before their retirement. At that juncture, my lord, their files have been returned back.
Yes.
And my lord, in this aspect, my lord, and already there's a settled position of law, my lord. Those have those employees who are though temporary, but they are serving in the church establishment, my lord, and they are getting their regular scale of pay for 30 to 40 years, my lord. They are entitled for pension, my lord. The Honorable Supreme Court, as well as the other honorable high courts of the country, have also laid down, my lord. And in that regard, we have also filed the affidavit in reply, enacting some judgments, my lord. Of
In item number 10,
yes, sir.
which are the judgments you are referring to?
My lord, judgment, I have annexed some judgment copy. First, I have annexed the copy of the Government of Assam OM, my lord. Page 84. 82, my lord. Page 84. And page, my lord, 92.
This judgment of Tulsi Bhai, Dhanji Bhai,
Yes.
which you are relying on.
Yes.
Do you have the High Court judgment?
This is
Because the facts are not clear.
yes, okay. The High Court judgments, my lord, appellate court is page 94. And single bench, my lord, at page 96.
Hmm?
Appellate court judgment is there, my lord.
Page?
Page 94, my lord.
94.
The land single judge may read, my lord.
Yes.
The learned single judge, after considering the material on record, came to the conclusion that in terms of Rule 25 of the Pension Rules 2002, the temporary services were liable to be counted for determining the qualifying period of service, and accordingly held that the writ petitioner had worked for 30 years and 9 months, and therefore he would be entitled to pension. Accordingly, the writ petition was allowed. We do not find any infirmity in order passed by the learned single judge, as the same is in consonance with the uh, statutory provision. The appeal lacks merit and is accordingly dismissed. Main, the writ petition, may I read the order of the writ petition, madam? Paragraph 2, madam.
Which
It is-
page number?
Page 96, madam. It is for the following prayers the present writ petition came to be filed, to declare and hold that the petitioner is entitled
No,
to.
but this judgment has also traveled to the apex court.
Yes, sir, it's there. Page number 92.
It is the same judgment.
Yes, yes, yes.
Party names appear to be different.
State of Gujarat versus Malan, Kalsibai.
Okay, yes.
May I read, Malan? It is unfortunate that the state continued to take the service of the respondent as an ad hoc for 30 years, and thereafter now to contend that as the services rendered by the respondent are ad hoc, he is not entitled to pension and pensionary benefit. The state cannot be permitted to take the benefit of its own wrong, to take the services continuously for 30 years and thereafter to contend that an employee who has rendered 30 years continuous service shall not be eligible for pension is nothing but unreasonable. As a welfare state, the state as such ought not to have taken such a stand. It is in the present case, the High Court has not committed any error in directing the state to pay pensionary benefits to the respondent who has retired after rendering more than 30 years of service.
You come to page number 99.
Lordship.
This is the rules, Rule 25,
Yes, sir. It is their service rule.
their service,
Their service.
their service rule.
In our case, it is 30, it will be 31.
Pension. Not service rule, pension rule. This is
Pension,
the pension rule.
pension manual. There are three conditions, my lord, in our service rule.
Yes. We
Page
have the
24. First, my lord, the service must be under government. Secondly, the employment must be substantive and permanent. Third, my lord, the service must be paid by the government. In provided that the government may, even though either or both of the conditions 1 and 2 above are not fulfilled, declare that any specified kind of service rendered in a non-gazetted capacity shall qualify for pension, and in individual cases and subject to such conditions as may think fitted to impose in each case allow service rendered by an officer to count for pension. My lord, we fulfill the above three conditions otherwise, my lord. And in our this honorable court also, my lord, explained in case of the page number 116, my lord, I have given. Our High Court has also, my lord, taken the reliance of this judgment of the Honorable Gujarat High Court and also our pension rule, my lord, and thereafter pass the order in case of WPC number 1777/2015, my lord, page number 102. Habib Ali Borbuya, my lord.
No, no. Rule 25 of Gujarat rules are different. There it includes service on probation, whether temporary or permanent, interrupted, etc.
Is qualifying service for subject to
Here
the,
in our case, it must be substantive and permanent.
Yes.
So whether in work charge will be substantive or permanent appointment.
yes, that is analyzed, my lord, in the judgment of our High Court, my lord,
Habib,
Habib Ali. My lord.
paragraph,
My lord, I'm paragraph 20. Starts from paragraph 20, my lord, 2023. May I read, my lord? I'm reading, my lord, paragraph 20, my lord. In the case of Tahsil by such and such, the apex court has upheld the decision of the High Court of Gujarat, wherein the High Court directed the state to pay pensionary benefits to an employee who had retired after rendering more than 30 years of service on ad hoc basis. The apex court held that to take the services of an employee on ad hoc basis for 30 years of continuous service and thereby deny him pension on the ground that he is not entitled to pension or pensionary benefit is unreasonable on the part of a welfare state. The High Court of Gujarat had granted pension in terms of Rule 25 of Gujarat Civil Services Pension Rules 2002, which provided that qualifying service for the purpose of pension would include all services in any capacity, whether temporary or permanent. However, the service was to be rendered in a pensionable establishment. In the present case, the petitioner's temporary service was never regularized or confirmed. Further, the Rule 1969 pension rules does not provide for grant of pension to a temporary employee who retires on superannuation. It only provides for payment of gratuity to a temporary employee who retires on superannuation in terms of Rule 125 of the 1969 pension rules, provided the employee completes not less than 5 years of continuous service at the time of retirement. Rule 108B of 1969 pension rules, on the other hand, provides for payment of proportionate amount of pension to a regular government servant who has been in service for not less than 10 years. In case of Dolly Pujari, the division bench of this court has held that the contract employee who was promoted without incorporation of the words on contract service in the promotion order and made to retire on reaching the age of superannuation, prescribed for all other employees of the state of Assam whose services were regulated under the rules framed under Article 309 was eligible to receive superannuation pension as the employee was serving under the government in substantive and permanent capacity for 14 half years, and as such, disqualification under Rule 31 would not apply to the service of the said employee. The division bench held that as the employee's service was purely contractual, the only known mode of putting an end to his service would be by the stipulation recorded in the contract or by termination of the contract by an appropriate procedure. However, as he had been made to retire on reaching the age of superannuation, as prescribed for all other employees of the state of Assam, whose services were regulated by rules framed under Article 309 of the Constitution, the said contract employees service would have to be treated to be substantive and permanent. The division bench further held that the contract employee, having received pay from the government as per the scale prescribed by the ROP rules 1998 and having received the benefit of increments and having crossed the efficiency bar.
there is a judgment of the coordinate bench. Mr. Lai, what do you say about that?
Lordship, that judgment is
very peculiar on its facts. It is referring to the post of Patwari. And the most important observation was that that person was working against a sanctioned post. But here, Lordship, work chart employees do not have any sanctioned posts.
From
And-
the principle of Dollywood Pujari.
There also, Lordship, the observation is serving in substantive and permanent capacity at para 23, page 106.
So almost in a substantive capacity to maybe work for 30 years.
Lordship, as per
How many
Upen,
years?
All are above 30 years, less. Someone is 40 years, someone is 35 years.
Lordship, as per Upenda's judgment, they have category held that the nature of employment of a work charge employee can never be substantive, Lordship, no matter how long the duration is.
My lord, the contract.
Because they work on a need to need basis.
This judgment Upendas was not referred. Or it is prior to Upendas. It's prior to Upendas.
Right.
No,
No, my lord.
it's after
After.
it was not referred.
The issue of Upendas is not same with that case, my lord. Issue of my lord, in those cases, my lord, the petitioners who were in the Upendas, my lord, they were not getting the regular scale of pay. They were getting the lump sum fixed amount on the per day basis, my lord. And they have prayed before this honorable court for a scale, regularization and scale of pay. And therefore, the honorable court has given, the government has also agreed that a minimum scale of pay we shall give instead of daily basis payment. That is there,
That's
but
right.
yes.
But there is a finding that other benefits like regular employees.
In case of those employees who are, my lord, in not case of employees who are getting the regular scale of pay, those employees who are not getting the scale of pay, only the fixed amount, my lord, they are getting. Or in case of those employees only, we are in the different footing, my lord, all along.
How can you be on a different footing in view of?
Because, my lord, we have been serving in a substantive nature, my lord. Because, my lord, we have been getting the regular scale of pay. We have been getting the benefit of increment, annual increment. We have been getting the benefit of EB crossing. We are getting the benefit of revision of pay rules, my lord. And some of the petitioners are also getting the benefit of provisional pension.
See, this is para 16 of Upendas.
Yes.
It's precisely on the point of consideration of the prayers of the master role worker for regularization.
Yeah. The question of regulation would not arise in case of our petitioners, my lord, because they are getting the regular scale of pay.
You show us an authority that getting regular scale of pay ipso facto means you are regular.
My lord, I'm placing some other. Okay. Yeah. It's Prem Singh, my lord.
Prem Singh is about consideration of your services rendered earlier,
Yes.
not on this issue. It is not on this point that merely because you are getting a regular scale of pay, you are deemed to be a regular employee.
But their pension, my lord.
Regular employee means there has to be a proper appointment. Post must be sanctioned. You must be treated to be, there must be an employer-employee relationship. Only then you will be deemed to be a person under service of the government and therefore entitled to pension. Here, you want to bring the proposition that you are getting a regular scale of pay. Will that automatically, because calling for pension will have to be pre-condition is that you must be an employee within the government, under the government, in a substantive and permanent appointment.
My lord,
as per the pension.
yes.
Then unlike the Gujarat rule, it does not include temporary or work as employee.
The services, my lord, which we have rendered in the department throughout the more than 30 years of service, my lord, that is under the government has taken our service, my lord, government service, my lord. Number one. Number two, my lord, employment must be substantive and permanent, my lord. Substantive, my lord, that, my lord, means the continuous service, my lord, in a particular scale of pay that we are getting, my lord. Amounts to itself substantive nature, my lord.
There is a difference. Even a contract work can also be substantive. That
But we are getting the
merely because you are getting a scale of pay, merely because you are working continuous.
Yeah.
Without being regularized. Purpose of regularization.
the regulation, my lord, in our case, my lord, chief engineer has done post-facto regulation, but that government has said whether it was with the government approval or not. That they are asking. But it is not our fault. That's why the Honorable Apex Court has
No,
stated, my lord.
absolutely, it is not your fault.
Yeah.
Doubt about it. The
You
fact
have-
remains that you have not been regular.
Well, the Rule 31, my lord, in our service rule, my lord, pension rule. Also, it can be relaxed, my lord. Provided that the government may, even though either or both of the conditions, 1 and 2, above are not fulfilled, declare that any specified kind of service rendered in a non-gazetted capacity shall qualify for pension. And in individual cases and subject to such conditions as he may think fit to impose, in each case, allow service rendered by an officer to count for pension. And the similarly situated, my lord, candidates have been given the regular pension. That is also admitted.
After regularization.
That the regulation is 1 day regulation that we have also got, my lord. That page number 64 is the regularization.
Are you regularized? Have you been regularized?
Yes, ma'am. The service of Sri Ahmed Hussain Chaudhary, work charge pump operator retired under the executive engineer. I'm reading from page number 64, ma'am.
Oh,
PHE Hailakandi division, who
page
read
number?
64,
Yes.
who retired.
You are the petitioner.
Yes. The service of Sri Ahmed Hussain Chaudhary, work charge pump operator retired under the executive engineer PHE Hailakandi division, who retired on the date as shown below, is hereby brought under regular establishment as per Assam Service Pension Rule 153 Note 1 with effect from date shown below. That is issued by the PHE, my lord. My lord, 153 Note 1, my lord, page number 190 of the Assam Pen. I'm reading, my lord.
Is it?
Though service in a work charge establishment is non-pensionable, members of such establishment may, on retirement, be entitled to gratuity under Rule 329(2) of the Assam Financial Rules, second edition. Such staff will not be entitled to any gratuity under above rule in addition to the gratuity admissible under the rule 329 of Assam Financial Rules. Extract of Assam Financial Rules is given.
So you are entitled to gratuity, that's it. Why do you say you're regularized? Regularized.
Page number 62, my lord, your lordship will come. 62, it is a pension settlement order and PP order, my lord, in respect of Jalaluddin Borbuye.
Who is he?
He is, my lord, the court charge employee like us, my lord. Page number 59 is the regulation order of him, my lord.
So
He
he's
will-
a similarly situated person.
Yes, yes, sir.
That we can direct the government to consider your cases. That's a different thing. But to claim it as a matter of rights, you have to towards the law.
My lord, I have given one judgment, my lord, from Allahabad High Court, my lord. It is 2024 Allahabad 201, my lord. Paragraph 37 and 38.
Paragraph
37, page number 11. May I read?
yes.
There are some of the employees who have not been regularized in spite of having rendered the services for 30 to 40 or more years, whereas they have been superannuated, as they have worked in the work church establishment, not against any particular project. Their services ought to have been regularized under the government instruction, and even as per the decision of the court in the Secretary in the state of Karnataka and others versus Uma Devi. This court in the said decision has laid down that in case services have been rendered for more than 10 years without the cover of the court's order as one-time measure, the services be regularized on such employees. In the facts of the case, those employees who have worked for more than 10 for 10 years or more should have been regularized. It would not be proper to regulate them for consideration of regularization as others have been regularized. We direct that their services be treated as a regular one. However, it is made clear that they shall not be entitled to claiming any dues of difference in wages, and they had been continued in services regularly before attaining the age of superannuation. They shall be entitled to receive the pension as if they have retired from the regular establishment and the services rendered by them right from the day they entered the work church establishment shall be counted as qualifying service for the purpose of pension.
This would have been possible, but for Upendas.
Upendas, my lord, has come in the year 2017, my lord. But we have been appointed in the year 1983.
So does it mean that for people
My lord,
appointed earlier, Upendas
mm,
should not be
No, my lord, I'm not saying that, my lord. I'm saying that, and my lord, as per the my lord proposition here given in the judgment, my lord, we have completed more than 10 years of continuous service without the cover of any court
give
or.
everything to you.
Yeah.
Now you tell us how you get out of Upendas.
Upendas is for those employees, my lord, those who are not given the scale of pay, they are given the wages only.
Read from para 16 onwards. Very clear.
It is in this background we shall examine whether the respondents who were working as master rule workers employees prior to 1/4/1993 can be considered for regularization in the light of exception covered craved out in paragraph 53 of the decision in Umadevi case. For ready reference, paragraph 53 is reproduced as under. One aspect needs to be clarified. There may be cases where irregular appointments, not illegal appointments, as explained in S.B. Naranappa RN such and such in para 15 above of duly qualified persons in duly sanctioned vacant post might have been made and the employees have continued to work for 10 years or more, but without the intervention of orders of the courts or tribunals. The question of regularization of the services of such.
Then you come to para 23 straight on. Para 23.
For these reasons, we are of the view that in fact situation of the case, master workers, workers and casual workers are not entitled for regularization for their services with consequential benefits such as pension, etc. We accordingly subject our direction in paragraph 22 of the judgment, allow the appeal and set aside the impugned judgment and order in the passed by the learned single judge. My lord, this is, my lord, not in respect of the, my lord, us. I am submitting, my lord, because we are getting the regular scale of pay from the day one, my lord. But
Or it may be there is a categorical finding.
my lord, the
No, no.
findings in respect of who are the petitioners? Who are the petitioners? The petitioners are those, my lord, who are not getting the regular scale of pay. They are getting only the lump sum pay amount, my lord. They approach the court, my lord.
No, sorry. That interpretation is not perfect. The judgment of judgment binding unless you say that the facts are entirely different.
Facts are different, my lord.
There is a finding here.
Finding is there, my finding, my lord, that
Tell us-
finding will not be applicable.
You tell us that this finding is contrary to some court.
My lord, Supreme Court has clearly laid down the proposition, my lord.
Which judge?
My lord, Supreme Court in the judgment of the Gujarat, my lord, they have Supreme Court has
The based on the rules. Rules are different. The rules permit temporary or workers employees.
in our case,
working
my lord,
without a break.
in our High Court, my lord, in case of my lord Habibullah, my lord, has analyzed the Rule 31 comparative with
Did
the.
not analyze Upendas. It's binding.
This is subsequent judgment, my lord.
How? How can it be? Which is subsequent judge?
My lord, this judgment, my lord, it was 5/4/2022. Habib,
Right. So therefore, the earlier precedent is required to be considered. Upendas did not consider that.
Upendas, my lord, Upendas, my lord,
No
is.
reference that Upendas of the fact not applicable. The judgment with all
This cannot be applicable because, my lord,
the judgment
how it
with
is not
all
applicable, my lord.
equilibrium.
Let me submit, my lord. How it is not applicable in our case, my lord, because, my lord, we are Upendas has said, my lord, for giving the minimum scale of pay. Minimum scale. We are getting the regular scale. Suppose we are covered by the, my lord, Upendas. Your lordship assumes that we are covered by the Upendas. We are getting the, what will be our condition, my lord? We are getting the regular scale of pay. We are retired and getting the full scale of pay, my lord. Therefore, how it will be applicable to us?
Then Upendas is not applicable.
Upendas is not
But-
applicable.
The finding that work charge and master roll are not available for regularization, we have to get. That is the, this is the question which was cited in, which was framed in para 60.
It will be applicable, my lord, subject to the conditions who will get this minimum scale of pay. It will be applicable to them only. Who will qualify for paragraph 25, 22, my lord. They will be subject to paragraph 23.
Very well, we have heard you. Anything more? You are arguing on a decided case law. This is not an appellate forum that we can redecide this issue. We have to accept for what is decided in the judgment. Unless you show that no, after Upendas, there are some judgment of the apex court where the different concept has been developed.
The lordship may, in that event, my lord, the lordship may fix another
We have
date.
given you enough time. How much time will we give you? We have been hearing this matter for endless number of days.
In that aspect, my lord, your lordship, it is developed, my lord. So let me,
Oh, we did not develop it for you. We thought you'll develop it for us to examine. Yes,
I am item number 317.
same
No, that my
similar fact.
similar, but my argument is very different. But
Item number
item number 6, my lord.
6.
Paragraph 10, my lord, I have stated.
Paragraph 10.
Paragraph 10 in my petition. That the petitioner begs to submit that considering the nature and status of petitioner service in the department, the service of petitioner may be presumed to have been regularized without any formal regularization order. According to the humble petitioner may be granted the regular pension as per the last scale of pay in accordance with law. My lord, here in this case, my lord, from the Upendas, my lord, with all respect, my lord, I beg to submit to your lordship to differentiate from this judgment, because my lord, here in this case, my lord, we are unfortunate, my lord, and probably, my lord, my learned friend will clarify, my lord, why those people, my lord, in spite of rendering more than 40 years service in the department, my lord, they are getting, my lord, regular scale of pay, even, my lord, pay revision also, my lord. And lastly, my lord, they are receiving more than 80,000 salary, my lord. And some of them are also receiving, my lord, provisional pension. But unfortunately, my lord, because of their, my lord, mistake, my lord, they are not regularized, my lord. Apart from, my lord, formal regularization order, my lord, they are every, my lord, aspect of their service is like regular service holder in the department, my lord. And now they are, my lord, opposing, my lord, the pension of the petitioner, my lord. That about, my lord, regularization of service, my lord, as per, my lord, the pension rule, it is not mandatory, my lord. Rule 31 is very much clear, my lord. Here, my lord, rule 31, my lord, it is provided that, my lord, service of an officer does not qualify for pension unless it conforms to the following three conditions. First, my lord, the service must be under government. Secondly, my lord, the employment must be substantive and permanent, my lord. Substantive and permanent, my lord. But here not regularization order is mentioned. That apart, my lord, it is in the proviso, my lord, it is provided that the government may, even though either or both of condition 1 and 2 above are not fulfilled. Government can, my lord.
We can direct them to consider.
Yes, my lord, as per this, my lord. This is
That's all.
at this stage, my lord, it will be better when then, my lord, if not consider, my lord, will come, my lord, why not consider, my lord? At this stage, my lord, that much may be given, my lord.
Yes.
Lordship, for item 6 and 7, Lordship may direct to consider, but Lordship, very bluntly, it is the same facts, Lordship. they are work charge employees, they are all covered by Upenda's judgment, Lord. And the argument of being left out, that has also been addressed in Upenda's. In Upenda's Lordship, the court observed that even those who were regularized, Lordship, that was also done in violation of Uma Devi judgment, because the state created supernumerary posts to accommodate them, which was actually not permitted. Therefore, Lordship, the court said that whoever has been left out will not get benefit on the basis of that, Lordship. And they are contractual employees. There's no legitimate expectation. They knew that their job will always be temporary.
How will you know? You have engaged them, you have expected work after them for 30 years.
Lordship, that is the observation in Upenda's, Lordship, about
They will not consider.
but the department can pass a reason order considering this.
Department has not passed. Department will take course with us.
Lordship, Upendas will have to be.
But if the my lord, Upenda's recourse is taken in case of us, my lord, if the recourse of Upenda's and fixation at the minimum scale of pay, my lord, where we shall go, I don't know, because we all along we are getting the regular scale of pay, my lord, and so far as my lord, the regarding pension, my lord, they have given to some humble submission, my lord, they have given to many people, my lord. I have given the one example. They have given to many.
Again,
They have given.
for consideration whether you can also be granted the benefit or not.
As my lord, your lordship will observe that yes, they have given to others also. my lord. In that time, your lordship will discuss.
Heard.
Right.
All councils have been heard here. Give your names to the court. Give the names of all petitioner and respondent. Counsel.
Yeah, please, your lordship. Lordship, in this matter, they were to file their reply. Health, NHM. And also state insurance.
Who has to file affidavit? NHM.
NHM.
This is for NHM.
Right.
Your affidavit?
One of them may be allowed for filing this, right? Additional affidavit.
What is the issue here?
Your mind, what is the employees working under NHM rate for granting them the benefit of employees provident fund. And also to incorporate the association under the employee state insurance scheme. That is a small prayer. But the matter has been pending since 2015, your lordship. In which they have replied, on reply, they have filed that they are granting this benefit up to 15,000 salary people who are getting 15,000 upfront. But their employees who are getting more than 45,000. So our issue was what about the rest?
On what basis is there any scheme?
Under the employees provident fund, we can rotate. The rule says that this scheme is applicable to every establishment which is a factory engaged in industry specific in which 20 or more persons are employed.
Yes.
Yes. This rule is applicable to every establishment which is a factory engaged in any industry specified in Schedule 1 and in which 20.
You're referring to which?
This is your lordship, the Employees Provident Fund and Miscellaneous Provisions Act 1952.
Section?
This is the section 1.
You're ready to argue the matter?
They have to file the reply, your lordship. When you reply.
Filed one affidavit in opposition, my lord. Up to
One minute.
15,000.
Lordship,
Granted, we,
maybe, Lordship, but I mean, for prayer, they might take some more time, Lordship, I mean, after the vacation, Lordship.
1 week time granted the respondents, HM, by their affidavit, matter be listed.
I just want to pray, Lordship, let it be taken at 2 o'clock. Senior counsel Hamid at 2 o'clock.
Second up.
Possibly my, and,
That RTI, my lord.
They've already completed.
Yes. The lordship was also noted when ordered is it is 29 to 24, all the details. And the additional affidavit was directed to be filed as regard additional pension that they have filed. And at page 85, they have shown that they have filed, they have given the additional pension beneficiary to the election, to the,
The only question is, the fact of the division bench is applicable,
yes,
by which you have
the
rejected.
proposition of law is applicable, I'll show it to your lordship. Although the challenge was on a different footing. The division bench, my lord, the information commissioners, they challenged the classification, that it is not a reasonable classification, the post of chief information officer and information officer. The honorable board came to the conclusion that no, this classification is based on intelligible difference here, so it is rightly done. There is no violation of Article 14. Right. But the proposition of law, I'll take your lordship to the division bench judgment. Paragraph 12, my lord. Paragraph 12 of the judgment. 12 and 13. 12. A further reading of section 16(5) of the Act 2005 would go to show that the State Information Commissioner are entitled to
One-
the
1 minute.
salary
1 minute. This is
division
right to
bench.
information act, is it? Provision of 16(5) of
16(5) of right to information.
Right.
Lordship, no.
Paragraph 12.
Paragraph 12, I'm reading. 16 minor lays down the term of office and condition of service of the chief commissioner and commissioner. Now, lordship, paragraph 12. I'm reading paragraph 12 and 13. The further reading of section 16(5) of the Act 2005 would go to show that the State Information Commissioner are entitled to the salary and allowances payable and other terms and conditions of the Chief Secretary to the government of Arunachal Pradesh. It is argued between the parties that the Chief Secretary to the government of Arunachal Pradesh is paid a pension under CCS pension rule 1972, which is expected below. Although, my lord, my submission will be, my lord, although the 16(5) says that they get a pay and allowances equivalent to the pay and allowances of the chief secretary, my lord. It is further regulated by CCS pension rules 1972. The rule 49, amount of pension. In case of the government servant retiring,
CCS bench. Yes.
49, man, it is quoted here.
Yes.
Amount of pension. 1. In case of government servant retiring in accordance with the provisions of these rules,
before completing service of 10 years, an amount of service gratuity shall be calculated at the rate of half month's emolument for every completed 6 monthly period of the qualifying service. 2A, in case of government service retiring in accordance with the provisions of this rule before completing qualifying service of 10 years, an amount of service qualifying shall be calculated at the rate of half month's emoluments for every completed 6 monthly period of qualifying service. B, in case of government service retiring in accordance with provision of this rule before
What
completing
is your prayer, Mr. Das? You're not asking, you're asking for pension.
They've given it to the state
They-
information. This is a case where the persons, they are seeking benefit of state chief information commissioner, they being the state information commissioner. And probably, my lord, the fact doesn't show, probably these persons are not a government servant. Here the petitioner is a government servant.
No, we wanted to know you're asking for pension, additional.
Pension and also some other benefits.
Or the benefit which is given to the
Chief Secretary.
chief secretary in respect of the peon and all, and also additional.
Yes.
The benefit of over 10,000 rupees.
B, in case of government servant retiring in accordance with provisions of this rule, before completing the qualifying service of 33 years, but after completing qualifying service of 10 years, the amount of pension shall be so and so. Notwithstanding anything, then Lordship may come to paragraph 13. A reading of provisions of Thesis Pension Rule 1972 rule would go to show that in order to be entitled for a pension, there is also a corresponding requirement of a minimum qualifying service for the person concerned to have served, and the minimum qualifying service would be 10 years. But when we look at the terms of appointment of a state information commissioner, we find that the terms of appointment is for a period of 5 years, and therefore it has to be understood that the minimum qualifying period of 10 years would not be satisfied in the case of state information commissioner. And my lord, that was the observation of the honorable court to come to a conclusion. Now, in our affidavit in opposition, that was the precise stand of the state government. Lordship will come to paragraph 4 of our affidavit in opposition. Paragraph 4, it starts from paragraph 4. That with regard to so the department back state that the petitioner is not entitled to receive retirement benefit equivalent to retirement benefit maybe of Chief Secretary Assam as a natural corollary to the office memorandum issued by the government of Assam pertaining to additional pension gratuity and the facility of telephone and a security assistant with fixed pay for the officers in the rank of Chief Secretary and equivalent to the government of Assam will not be applicable to this case. In this regard, the judgment dated so and so, reported so and so is being relied upon. That's paragraph 12.
The statute does not require 10 years of service.
My lord, CCS
Statute. They're appointed under this act.
16.5,
65.
but 16.5 is further by not qualified by CCS rule 1972.
How?
Because the Chief Secretary is getting under all the officers are getting under that rule.
No, are you?
That
Let us going by your submission.
My lord.
The chief secretary, the benefit of which you will get, according to you, is the person who seeks that benefit must qualify
under the
the requirement of 10 years.
10 years.
10 years or so.
Yes, sir.
Now the chief secretary is working as a chief, what is the chief information committee?
Chief Information Officer.
Chief secretary is, will qualify for
State information.
state. No, in the state, there is a,
State Information Commission.
and then
State
Chief
Chief
Inform-
Information Commission.
that's what we are saying. State chief information is held by whom? By a person and the rank
But
of chief
he,
secretary.
even they could also.
Okay.
As that of an election commission. He is equivalent to.
He is equivalent to election commissioner vis-a-vis the judge of the Supreme Court.
Now, therefore, if this analogy is drawn, then this 10 years required where?
In the post, subsequent, the final
That
information
is not
commission.
the mandate of the act. The act is the source of the power for appointment and giving the benefit. The act does not prescribe that.
Act doesn't prescribe, but that rule prescribes.
And that rule prescribes service not in the post,
Not in that particular post, but the post.
other service.
My-
So far as the writ petitioner is concerned, there is no quarrel that he was a civil servant.
He was with it.
He was a civil servant. That's why the 10 years or 15 years or period you require.
But the stand, as it appears from here, stand of the state is that the chief secretary, in case of, he gets a salary equivalent to the chief secretary of the state. Chief secretary is also, it is turn governed by CCL rules. CCL rules, my lord, there is a qualifying service requirement for qualifying.
Qualifying for 10 years is what? Can't be chief secretary.
It can be,
It has to be.
can be chief information officer.
We go by your pension rules. If you rely on this requirement of 10 years of qualifying service, then are you suggesting that, are you submitting that 10 years of qualifying service must be 10 years as a chief secretary?
No,
Then 10 years as a civil servant?
civil servant, but he doesn't come under that category, the petitioner.
He has 10 years of service, more than 10 years of.
10 years of service, but not having that CCL. He is not under the CCL.
You are governed by what rule?
CCS.
CCS rule. He's a civil servant.
That is the stand of the state taken in the agreement. Paragraph 5, my lord.
Yes.
The writ petition, the Supreme Court said that the petitioner who demitted as Chief Information Commissioner on pension will be governed by Central Civil Service Pension Rule 1973. In case of pensionary benefit, Rule 48, 49, and 50, etc. The petitioner retired from present service of Government of Assam in 2014. The reading of the provision of Central Civil Services Pension Rule, more particularly Rule 45, shows that in order to be entitled for pension, there is also a corresponding requirement of minimum qualifying service. For a person concerned to have served, the minimum qualifying service would be 10 years, but at per provision of so and so. The appointment of state, it is found that the term of appointment is the same thing.
What
It is
exactly
quoted
are
from
you
the-
trying to convey? 10 years as qualifying service or what? As what?
In a feeder, not feeder, my lord, it is a different post altogether. In his entire service.
Is that that service? He is also governed by CCS rule. In his parent department. You are employed as what?
For example, account,
Earlier he was accountant general. Now he retired as an OSD to the accounts. Indian Audit and Accounts.
So you are governed by CCS rule.
Yes, yes.
Central government rule. If it is a case that no, he was, he was under the government of Assam and therefore not governed by CCS, is one aspect. But he was governed by CCS. Assuming, let us say, assuming he otherwise qualifies for his service, he is rendered to the government. Is he not qualified for pension under 48, 49, 50?
Under central government, yes.
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 So he satisfies that.
He was, my section, he was not governed under that situation.
Okay, we'll come back at 2.
Hello, I would like to give the copy of the writ petition where the division bench judgment of the in Arunachal matter is.
Division bench judgment,
Division bench judgment has been passed in the
Ah.
Arunachal matter.
this remand.
Yeah. So there, I'll just give a copy of the writ petition. There they do not say, but I'll show the prayer only.
You want to say that they were not government servants.
They were not government.
Therefore, the requirement of 10 years was
It doesn't even.
required. We come back at.
Your case is going on.
Lordship may also come to our additional evidence at paragraph 5. Additional evidence 5. The deponent order states that between SCIC, AICC, Himanshu Shekhar Das retired from the post of Assistant Chief Secretary Assam in 2000. Whereas C. So and so, ex-IAS, retired as an officer on special duty in the office of Principal Accountant General Guwahati, Assam on 2014. As such, according to the Central Information Commission order number so and so dated 5782, benefit of additional pension, etc., can be availed by those who work in the rank equivalent to the that of election commissioner. Government of India. Here in the present case, the petitioner so and so was ex-IAS and retired as an officer on special duty in the office of Principal Accountant General Guwahati on 31/12/14. After his retirement, he served as State Information Commissioner Assam, and being joining this post, his rank was not equivalent to election commissioner. But in case of C, it says thus his rank was equivalent to the retired, as he was retired as the additional chief secretary Assam.
Where is that office order? CIC office order?
That we have not annexed office now.
No, it is there, page 40.
In report of
Page 40 of the report.
upon revision on pay allowance of the chief election commissioner and the election commissioners of India pursuant to the issue of High Court and Supreme Court judges, the President the pay of allowance of chief information commissioner and information commissioner have been revised. Right so and so dated 23/4/18. Order to the revision and implementation of salary and pension provision for upper limit, additional pension and gratuity benefit to the Chief Election Commissioner of India and the other election commissioner of India as adopted from notified High Court and Supreme Court judges salary amendment act so and so. The pension provision of upper limit of additional pension and gratuity benefit to retired Chief Information Commissioner and Information Commissioner are revised with effect from 2016 in the Central Information
This is only
Commission.
with the revision.
Revision.
To do with the conditions necessary to fail. Private facie there appears to be no bar. Interpretation, even in the division bench,
Interpretation, possibly the interpretation of law may be that may be applicable. Only thing we have not said anywhere which rule was applicable in their case prior to his appointment as information officer.
he retired from the office of accountant general,
I
special duty.
I have checked every our division everywhere. There is no mention of which should be there.
Has to be had that case,
I cannot concede, but it CCS rules were applicable in their case also. So I think I cannot concede.
but don't have material. Kapi Rado,
It is silent about. The evidence is silent. Even the additional evidence is silent. There is no which.
and where is the judgment of the single judge?
It is annexed to the repetition.
Single judge judgment. Coordinate bench judgment.
Page 59.
Page?
59.
61 is right.
Relevant is at page 63.
So para 6, the earlier objection that they did not serve as the secretary. Has been held to be unacceptable. In para 7. And no appeal has been filed against. For it.
No, after that, my lord,
It's single bench rendered this finding in a writ petition filed by petitioner himself along with others.
And there
Page number 60.
is number 60, yeah. Petitioner himself, yes.
There's a finding by the court that
The direction your lordship will see, accordingly, the respondents are directed to pass a reasoned order
that's right.
on the claim of the two writ petitioners for their service benefit. So this was subsequently rejected by.
Right, but you rejected it on the same grounds which have been held to be bad by the, which has been turned down by the court.
Following the division bench Arunachal judgment by the, this was found.
The dash.
Yes.
Go to the
Well, only that, only.
if you can show
That-
from some provision
Hmm.
that this is a this mandatory requirement, that there is a special requirement that he has to be a member of administrative
Sure.
body.
But if he is governed by that rule particularly,
No.
prior to his appointment as,
He is governed. The central government by the
that of course we do not say, there is no whisper. If he be in opposition, neither in the petitioner. Or may I have that instruction, whether they were earlier or governed by that? Because qualifying service means kind of the previous service, not the, to my understanding,
cannot be.
mine, cannot,
It's only for 5 years.
it is only for.
Unless you say no, it gets renewed for 3-4 terms. then
That
But
was the
that
vital information which is
that is
lacking.
not the mandate of the sector.
Right.
Mandate of the sector is very right. Very good. You tell us what, how much time you requiring.
Huh? After vacation,
Forget it.
It is going by piece. A privilege on their part.
no, only that much of information, my lord.
That they
Otherwise,
can get it now only by giving a telephone call.
We keep it on 27th, you get it. 27th.
I'll find.
Otherwise, I have stated in paragraph 2, my lord, on 13/12/83, he has joined as Indian Audit and Account Service as a provision. 83 onwards. This is not denied by anybody.
We keep it on 27th.
Part not only.
Further. It's on 27th.
Take on more question.
Argument of the the request of
Really keep on. You keep up. Whether he worked as he was governed by. Whether he was governed by CCS rules. But
certain instructions you like. It's not 27th.
and specifically if your lordship direct them to provide whether he is governed by CCS rules.
Let them get whatever
Well,
instruction. That is the only thing that they want to get it, otherwise
yes, 83,
Otherwise,
I
I
have
have
stated, my lord, I don't know why
Otherwise,
they 27.
the
Doctor, I'm giving a bunch of judgments.
you're relying on some judge.
Some
Contact.
Hmm?
But all contact with the doctor.
I think it's contextual telling matters.
Contact with doctor. Tapi Saturday and Wednesday.
First, first, on the point of contextual appointment, that petitioner is eligible is on judgment we had given you earlier this will indicate.
Madras High.
Madras, like,
It will be after number 1.
it's serial number 1. And serial 2 and 3 relate to doctors. The doctors are also eligible.
Saturday, Wednesday.
Serial 4 relates to salary and wages. Apex court has held that both are same. The question was raised by your lordship last occasion.
The primary 5 to 8.
Go to both, right?
Yeah.
Higher post वाले salary, higher post.
The Tribunal Court was held in higher post is normally salary, termed as salary and lower level wages. And I've been termed as a salaried person. You know, he was in the report.
It number 21 of the salary. Fixed salary 12.
Report the lordship is evident, I will pay the salary. That is at page 21 of the writ petition. And
Why have you relied on
on
Whirlpool judgment?
alternative
Alternate.
there's no dispute regarding fact, and admittedly there isn't. A question of law,
Serial number 8. Paragraph 11. Page 7. Page number 8, paragraph 7. Page number 8, paragraph 8. In the last judgment, serial number 8, paragraph 16, page, you will see paragraph 16 at page 7 and 8. 7 and 8 will not. It's paragraph 16 of the last judgment. Page 7. Madhya Pradesh High Court.
Yes, para.
16. 16 at page 7.
Alternative remedy, yes.
Here, calling from the Supreme Court, they stated 7 will recognize exceptions.
No, I think your judgment. Yeah. Voter is thoroughly.
Certainly, and that I've already stated that is a serial number 4. It's
Right. Right of the judge.
Yes. At page 365, it has been noted that it will thus appear clear that conceptually there is no difference between salary and wages, both being a recompense for work done or services rendered, though ordinarily the former expression is used in connection with services of non-manual type, while the latter is used in connection with manual type. Basically, that another aspect your lordship is pointed out was regarding paid in cash. Not necessarily salary. The question of paying in cash does not arise, but otherwise also in cases of wages, nowadays payments are made digitally through the bank. Wages means all emoluments. Emoluments means salary. Wages means 2 years. Emolument. Will repeat all of these.
My submission is that you worship. I'm entitled to gratuity and admittedly, they say I've completed 13 years of service. 14 years. बोला थे
Yes, I will.
Well, actually, my lord, that there is a procedure prescribed in the act. Well, first thing, my lord, it will also see that Rule 7, you'll notice with that why it is missing. An employee who is eligible for payment of gratuity under this act or any part authorized in writing to act in behalf shall apply ordinarily within 30 days from the date of gratuity income payable to it. Provided that where the date of superannuation or retirement of an employee is known, the employee may apply to the employer for 30 days of the date of superannuation. The first thing, my lord, they mainly state, my lord, superannuation or retirement. And that has been said in the act also, my lord, which will also be. That page section 4, my lord. Section 4, where it is.
Section 4.
That same word which my lord used here. Gratuity shall be payable to an employee on the termination of his employment after he has entered continuous service of not less than 5 years, on his superannuation or on his retirement or on his death or disablement due to accident or disease. And here appointment was specific, my lord. No other thing.
No, but there are judgments where it says contract appointment, temporary appointment. How is that covered?
But in the appointment letter, my lord, we have also seen, especially in the affidavit also, it is in our institution also, my lord. What is it? Annexure 1,
Page 15.
page 15, my lord. Page 59. Page 59, my lord. That has been accepted by the Bharat.
Right.
Apart from the contract salary, well, that first they would advance to the interview of the chairman management is to offer you the post of medical officer, the association contract salary of 12,000 per month. He is a retired employee, my lord. He will contribute 12% of the salary, the provident fund account, and the association will make the equivalent contribution. Provident fund has been included. Apart from contract salary, no other charges or other allowances will be. And now, whether he is entitled or not, my lord, that there is a
Now,
proceed.
after there is this communication for disengaging him or ending his
No,
contract.
automatically, my lord, because he has been extended on this basis of the letter, then after completion of the period, my lord, he automatically ceased to be. No,
When was he retired? When did this
Uh,
An issue of 5,
next up, five.
page 15.
Page. Protector service the PRA has been completed on 39. I'd like to thank you for the professional working.
So automatically, my lord, it has gone, because if you'll also see the data. The extension is complete, my lord. Now, this is a controversy, my lord, that act provides, my lord, that the authority has to determine, my lord, first they have to go there. Section 7 says, my lord, they have to approach them. And there is this is a, my lord, proceeding like a judicial proceeding, my lord. Court of appeal procedure is applied. Thereafter, my lord,
In all the
in those cases, my lord, they have approached the controlling officer. And the controlling officer is provided, my lord, here.
set.
This is what we are supposed to do with the court.
My lord,
We are supposed to determine whether he is covered under these provisions of the act or not.
actually, my lord, in view of all these things, my
There is
lord,
no factual dispute.
actually, my lord, because this appointment letter itself, my lord, excludes him from any other thing.
Right? So there is factually no dispute.
Yes. Then, my lord, then controlling authority is provided, my lord. Controlling authority, my lord, he is to decide first. Then there is an appeal. They have to approach the controlling authority. If there is, the controlling authority is mentioned, section 3 is the controlling authority. And they have to file an application for the controlling authority. And the procedure has been prescribed in Rule 11, my lord, how it is to be done. 11, 12, 13, all are the procedure, my lord. Even oath is administered. Then there is an appeal against that. That appeal is also provided, my lord. So whether under 227, Act 6, my lord, your lordship will exercise your lordship power.
We have to decide whether this act benefit, whether this act is conferred or not. There is no disputed question of fact. The facts are undisputed. Is appointed on a contractual basis. Contract and date on.
Yes, correct.
Now,
That
there
is
are
fine.
the circumstances.
Only thing, my lord, that the appointment letter itself, my lord, he accepted it, that no other allowances will be applicable.
So, whether under section 4 is he eligible or not.
Correct.
That's the only issue.
My lord, definitely.
So we keep it for another day. Let's see if we can dispose it of the next day.
My lord.
Let it be after the vacation.
Yes.
Or, First of all.
My lord.
Item 21.
In this particular case, the lordship, last occasion, there is a direction to decide my miscase, which was I have filed, my lord. File number, my lord, 1624, my lord, 23. Matter, I have filed, I am appearing for the respondent number 3, my lord, Chairman of State Bank of India, my lord. Here is a case, my lord, we have filed here for deletion of the name, yes, because, my lord, here his petitioner's claim is against the, my lord, respondent number 4 and 5, my lord. And, my lord, we have made a party only because of that, my lord, we have a, my lord, holding company, and the correspondent of 4 and 5 is a, my lord, subsidiary company, my lord. And both the three companies is registered under company X, my lord. We have no interference each other's, my lord. Here is a case, my lord, he, my lord, not a single line, my lord, where any relief is sought from the respondent number 3. That is my case, my lord. I am not, my lord, concerned about the 4 and 5, my lord. His case was, my lord, due to non-payment of the, my lord, credit card payment, my lord. His civil is down, my lord, respondent number 4. So I am from the chairman, my lord. Here the chairman of the State Bank have nothing to do anything in this particular case. My lord. That is my prayer, my lord. So, my lord, my case and another extra also, my lord, I have come against that it's not covered under section 12 also, my state. So that is my prayer, my lord.
My lord, SBI is a necessary party and I can prove it. The SAM SBI card, in SBI card, SBI hold 70%.
How does it matter? Who operates the SBI card?
Yes,
Is it through regular SBI retail banking or is it a separate company?
my lord, both are separate entity,
Then
separate legal person.
Okay.
But my lord, SBI appoints its chairman. SBI's chairman act as the chairman of SBI card. I have memorandum and article of association. I would like to rely upon that document of SBI card. And in the definition of article,
what is your prayer here?
yes, my lord, cancellation of the credit card and my lord, removal of the adverse effect of the credit card upon CIBIL score and
Why
publication.
have you come to a writ court?
Yes, my lord. Actually, ombudsman cannot take jurisdiction. Only for deficiency of service, ombudsman can take cognizance.
Go and file a suit. Why didn't you file a suit?
My lord, it's maintainable because article respondent number 4 is covered under article 12 of the constitution.
Maybe it is.
And there is violation of public duty, my lord, and it also perform public functions, my lord.
What public duty?
Yes, my lord. I am going to prove it, my lord.
What is the civil credit?
My lord,
What is civil credit?
civil.
Well,
Civil.
I appeal for respondent number 5 CIPL, Malad.
What do you say?
This is a Malad private entity, Malad, constituted as per RBI Act, Malad. RBI has given our Malad a license, kind of license, Malad, to, we are a repository actually. So we take track of the Malad issues regarding payment card, payment defaults and all, Malad. So he had a SBI card, Malad, credit card. So he had default and automatically the bank has supplied the information to CIBL. So that is our duty. We have to maintain the data. That's all. Now, my lord, he has claimed certain compensation amount to crores of rupees, my lord. 50 lakhs.
What?
Yes, my lord, amendment petition is.
No, whether this petition is maintainable.
Civil is not a private entity, it is a public entity. It was created under the instruction of Reserve Bank of India. And my lord, long before it was created, before the enactment of Credit Information Companies Regulation Act, because it was very much necessary. Parliament decided, and thereafter RBI was entrusted. I have the history of creation of CIBIL. There is minimum paid up share capital of CIBIL, and there is legal.
I understand everything. Now tell
Yes,
me,
my lord. Now I am going to.
this limited the what is your prayer in the writ petition?
My lord.
Please bring your prayer in the
My lord, cancellation of the credit card, particular credit card disputed, and removal of the adverse effect of the credit card.
The cancellation can happen only once you start paying the due.
No, my lord, actually, once a credit card is issued, my lord, then due accrued. And I have already paid them 3,166 because they have pressed concern against that this is my due. And as it adversely impact my civil score, and I am a businessman, my lord. In the writ petition, I have annexed to contract which was entrusted to me by the PWD. The value of this contractual,
How is it relevant here?
my lord,
How is it relevant here?
my lord, I do my business. I am a businessman.
You may be a businessman, so how is it relevant?
Yes, my lord.
What is the court
When
supposed to
civil
do?
score, when civil score decline, bank does not release
You
my.
go and file a suit for compensation. Why have you come to a writ court?
My
Who's
lord,
stopping you to go and file a suit for compensation?
writ jurisdiction,
Damages.
writ jurisdiction is available, my.
This is available. We were disinclined to exercise the writ jurisdiction in these matters. These are disputed questions of fact. These are disputed questions of
My
fact.
lord, when writ jurisdiction is available, honorable court should
No,
entertain
writ
it.
jurisdiction is the discretionary jurisdiction.
Yes,
We may or we may not.
yes, my lord. There must be reason, my lord.
Yes. Your civil score is affected. You are affected by the public image. Go and file a compensation.
My lord,
Suit for compensation. Damages.
my lord, only ombudsman can hear it, but there is no deficiency of service. And my lord, once
You
we
file
have
a
not.
suit for compensation. Will give you liberty. Your grievance is that your civil score fell
Yes.
because of deficiency or shortfall on the part of the respondent.
Yes.
What do you want the writ court to do? Issue a writ to hike your civil score?
No, my lord, those are wanted. Along with it, my lord, compensation is also
No,
one.
we can't give you compensation like that. On what basis are you quantifying the compensation?
My lord, I shall file estimate of damage.
What do you mean you shall file? Why have you
By
not filed
filing
it?
additional affidavit, my lord.
No, we don't permit you to file an additional. For what purpose? You're wasting time.
No, my lord, a lot of damage has been done to my business, not only
You
business,
file
my
a
lord,
suit for
financial
damages.
business.
Why don't you file a suit for damages? File a suit for damages. Who is stopping you?
My lord, as jurisdiction is available, that is why.
If jurisdiction is available not to quantify your damages. Why should we quantify your damages? It requires evidence. Some facts are there. There are disputed questions of fact. You say something, they will deny it. How does the report prove it? How will you prove it before the report? On what basis?
My lord, it may kindly be reflected in the order that we should file a civil case.
It is up to you. You withdraw it, we'll give you liberty. Or we can dismiss it and give you liberty. Either way you want.
My lord, one date may kindly be given.
No, no.
I shall take instruction from my client. my lord.
No more date. What instructions will your client give you? You're the lawyer. You are supposed to instruct,
Yes,
advise your
yes,
client.
my lord.
What instructions will your client give? Yes.
My lord, if I withdraw, I shall be given liberty to file civil suit.
Yes.
Okay, my lord. It's
But- Praying for a direction to the respondents to cancel the SBI card hearing number issued by the respondent to the petitioner with a further prayer number 5 to remove the adverse effect of the SBI credit card on CIBIL CIBIL France Union score provided by respondent to 5 after cancellation of the card by the respondent board and a further prayer to the respondent to 5 provide new civil score France Union instant with the petitioner and publish it after removing the adverse score on the sales credit card of the petition. And others repair. The petitioner is before the court brief that the credit card issued by the respondent number. Who issued the credit card?
SBI card respondent number 4, my lord.
Respondent 4. Issued an SBI credit card, and because of and according to the petitioner, because of dues that reflect the credit card statement, which are not supposed to be paid by the petitioner, its civil score, CIBIL, civil score, maintained by the respondent number 5. Reflected adverse score of the petitioner. Petitioner claims to be a businessman of repute in the business of construction and civil score, adverse civil score, has the effect of altering his financial credibility before the financial institution, and therefore he is something for the court with the prayer made. Learned counsel, Mr. Also appears for the respondent.
I am for respondent 3.
You are for
Respondent number 3, chairman of SBI, my lord.
respondent 3, respondent for 5.
5.
Who's for 4?
Who is that?
Respondent 3 and 5 are represented by the counsel. The upon hearing the counsel's the party that the primary claim of the petitioner is a claim for damages, which the petitioner seeks to file by additional pleading, and for a direction to the respondent number 5, alter civil ratings of the petitioner in respect to the considering the prayers made and all the court not finding in the court with the disputed the fact that is before the court without the required evidence that we required support arrived at site of great petition, therefore, after arguing some after the petition but through the petition with further I for damages and other relief has been justified. In view of the prayer liberty granted, the petition avail remedy as permitted.
My lord, I have a small little prayer, my lord. Here, my lord, my prayer, my argument will be recorded. Otherwise, my lord, as here, my lord, chairman has nothing to do in this particular
We are
case.
dismissing the petition. What is there to be heard?
Tomorrow, my lord.
No, really.
Tomorrow, my lord, again, he, yes,
Recorded your name.
that's true.
Even if we record your submission, after we have dismissed it, these are not maintained.
Always, my lord, chairman has nothing to do. Otherwise, my lord, in tomorrow, he will make a party, my lord, then, my lord, again,
My lord, chairman, State Bank of India, State Bank of
Nothing
Islam
to do with it.
specifically stated,
Approach the civil court, file
Yes.
a suit,
Oh,
and
my lord.
inform him
my lord,
so that he can come and
My lord.
defend his client.
my lord. Oblige, my lord.
Article 22.
Yes. What is this?
Please, your lordship. In the morning, I mentioned this matter. In the morning, your lordship, I mentioned this matter. Your lordship directed me to wait till the matter date. Your lordship, otherwise the pleadings are complete. Otherwise, the pleadings are complete. your
Therefore, we wanted you to argue the matter. You're not inclined to argue. What is this cancellation?
lordship. We are
we are
Reliance Jio my lord petrol pump. So we are having a petrol pump within that 1,000 kilometer. So the law says that, my lord, that there is an exception, 4.6. We can do it, my lord, provided we make that approach road. 7-meter approach road, we make it, construct it, then it is allowed, my lord. So we are in the process of taking permission, depositing fees. But my lord, they got an interim say, because of that, everything is halt, my lord.
No, why are they agreeing?
They're agreeing with my petrol pump coming there, my lord.
Why not actually?
It is from Barpeta to Guwahati, my lord. So where the, along with the highway, we are having a Reliance petrol pump, my lord. They are objecting to that. Your lordship may claim fee 4.6, my lord. Well, it my vacating application. I have shown the guidelines, my lord, page 31, my lord.
You are also running a petrol pump.
Yes, your lordship.
But that their petrol pump is yet to operate, madam.
It is yet to operate, but your lordship, the
But they have made a specific statement that it is operating. And that's why they got to say, madam.
When is Mr. Raj coming?
your lordship, most probably today, your lordship, but if it is not inconvenient, it can be taken up on 27th, your lordship, subject to your recommendation.
27 is the last day, my lord. Before that, it can be, my lord. The 28 is last day, but
Is the Hulun?
let it to 25th, my lord.
25th.
My lord.
It's not 25th. And by around that. Done. 26th. Okay, right. I'm already, my lord. You are appearing for? You are appearing for?
But I am for 5 and 6, my lord.
5.
I'm assisting.
I'm appearing on behalf of TT. National Highway.
For the phone number 7, my lord.
Okay.
8, 7.
1 to 1.
Lordship, there's a hindrance that may kind
Till then, my lord, and lordship means observe that the endeavor will make to dispose of the petition, my lord.
Why do you want an observation? Press will discuss it.
keep your breath.
For hearing item.
Well, before my friend start my in this smaller group of matter, the revenue department is a necessary party in but the no affidavit is filed in this case by the revenue department of Government.
Who has filed? Not his frontier railway.
Yes.
Lordship, may I state, Lordship? Here, this first petition is by Railway, Lordship. This petition is filed for seeking some cooperation from the state government during the eviction process. For maintaining the law and order situation, Lordship, we have wrote a number of letters. At first, they always admitted to cooperate with, but for the last moment, for some reason, they are not cooperating. So we have filed this writ petition only for a direction to the state government to cooperate. 32 and 33 are two pages, whereby the authorities, the higher authorities have also directed previously that they should cooperate with the railway authorities during the eviction process. During this pendency, Lordship, an affidavit in opposition filed by state government stating that they are not cooperating because of the interim order passed regarding eviction filed by the writ petitioner, where by my learned colleague, Lord. Then I came to know that writ petition where an interim order is operating is only relating to the one T state, Sipkota T state. So for that other part of land lordship, there are no interim order. And I have also filed an additional affidavit that the areas, and to show that those persons who are residing are unauthorized occupant, their cases were considered, they have no valid cases, they have not preferred any appeal, but they are still occupying those land. And the interim order is in respect of one tea garden lordship, which are the subsequent writ petitions. So my humble prayer is that, so though interim order is there, leaving apart that part lordship, the authorities may cooperate with for eviction in other areas where no interim order is there, Lordship. That my limited prayer in this writ petition. And if Lordship sees those other connected writ petition, all those are only to that Sipkuta tea garden, Lordship. The writ
You can just
petition,
see the interim order, but
yes, Lordship.
the interim order passed where?
In WPC 4610 other writ petition, not the 23, from 24 to 24 onward.
Who has filed the additional affidavit?
Additional affidavit is by railway Lordship. To show that for the areas we have due process of law, we have issued eviction notices much prior Lordship.
Where is the interim?
Like item number 24.
Item?
Item number 24. WBC 4610.
Order dated Lordship 12/7/22.
Similar order in all the connected. Order. Our contention in the writ petition is that my lord, the land belong not to the railway, belong to the government of Assam, my lord. So my lord, the affidavit from the revenue department is required in the writ petition for proper.
What affidavit has been filed here
Government.
in this writ petition affidavit?
Well, no, item number 28 only, my lord, affidavit has been filed by the railway, not by other.
So in 4610,
No, nothing.
yes, revenue. Who's for revenue?
Otherwise, revenue affidavit is not required, yes, because of it. It is a notice was issued under the public premises unauthorized occupancy. It's a section 5 notice and section 4 notice. Against that, there is still
There is an order of the court directing respondent seeks to file an affidavit.
that part I know. Otherwise, was it a appeal?
You see the order 4610, you see the order 12/7/2022.
That part I know. Otherwise, it's a appealable order. It's a section 9. They have to file for jurisdictional or district magistrate. They have to appeal.
No, that was my lord, approach, my lord, that has been disposed of.
I have not done.
That was not.
That was
That
not
was
done.
not.
They directly came before the
My lord,
order.
the order, your lordship kindly peruse the order.
Where is the notice in
Notice,
4610?
your lordship,
Notice,
notice by the estate officer, your lordship, will find from page 45 onwards, my lord. 44 onwards, my lord. Then appeal was preferred before the district judge, my lord.
what order was passed?
Page 61, my lord. And the order portion, your lordship, will find page 70. Relevant.
ऑफिस के बाद ये गया है, इनके लिए गया है। हाँ, वो जो ऑफिस इसमें तो इतने वो भी पिक्चर में बहुत सारे पिक्चर हैं
So the appeal is against what?
Against them, my lord, the notice issued by the respondent, railway. Yes, sir. Terms of section 9 of the public.
Then what is the meaning of the para 18?
वो नहीं है ना, नहीं केस में तो
Despite that order passed by the appellate authority.
Read the order, page 70.
Relevant for 18 parameter. Taking into account the objects and reasons of the act, I am of the considered opinion that if the estate officer is of the opinion that any person are in unauthorized occupation of any public premises, he or she can proceed with the provisions of Act of 1971 and rules made thereon. Our contention is that land we are possessing, my lord, is not a railway land,
Your appeals were filed by you.
my lord.
Now the appellate authority has given permission to the estate officer
My
to
lord.
see.
My lord,
But the notices were issued under the Act of 71 only.
my lord.
What is the meaning of para 18?
But my lord, the land not belong to the railways, my lord.
That is what was the.
That's why, my lord, revenue department affidavit is required in this case, my lord.
There was a direction also.
So revenue department, what is it?
Railway department in item number 20 file an affidavit in opposition, my lord. There is no mention of any allotment order, settlement order, my lord. Any gift deed, sale deed, my lord, in favor of the railway by the government of Assam, my lord, or by the Union of India, my lord. Claiming
If it given.
in the read petition filed by the railway, my lord, the item number 23, my lord, there is no mention of any allotment order, my lord. Any settlement order of land belong to the railway, my lord.
we are not made party, my lord. 24 item number 22.
WPC 4610.
Yeah, 4610 তে order হয়েছে।
After vacation, my lord.
Let the affidavit up because yes, there is an order.
Lordship, that other cases only to that Calcutta tea state, other land lordship possibly, but anywhere lordship is
The connect-
all are connected matters, so may fixed date be given and that case lordship. Deputy Commissioner file their affidavit, my
By
lord.
the order 3 passed by the order dated 12/7/2020 directing the order number 6. Namely the state of Assam represented by the file. It is not been filed. They get setting up the hearing for the six, the prayer, filing. If there is a specific direction that one file will be granted, six file stating which the court matter terms of the already. Let the matter be listed again. 6th of August.
Of like.
Interim order may come
Order passed.
in all the.